up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On June 23rd, 2024, the Texas game warden on patrol were enforcing water safety compliance on the San Jacinto River. The Texas Wildlife Code grants the game warden's authority to make water safety inspections. The officer observed a jet ski flipped upside down, and the two occupants having difficulty getting it turned over and back on. Officers stopped to help and got the two people on board the officer's boat. Officers asked the two what happened, and the male said that they lost control and fell off. Defendant was observed operating the jet ski and ID'd by his Honduras consultory card. Officers observed an odor of alcohol on the breath, bloodshot, red, glossy eyes, and the defendant said that he had had 4 beers. The defendant did not have a boating education card. HGN was 6 of 6. DIC was red with a BAC of 0.127 and a 0.136.
Did they take him back to some kind of station to take a breath test, or was that a PBT?
Let me take a look, Judge, just to be sure.
They did take him back and then also did walk and stand and then, or one leg stand and the walk and turn.
At the station?
Yeah, he was booked at the station, Judge, and that's where they just asked.
Where was this? What station was he booked at? That's interesting.
Was, so it's, the agency is Texas Parks and Wildlife, but let's see.
It's Harris County Joint Processing.
Wow, they brought him all the way over here. I wonder
Yeah,
how
right
far. Whoa, okay. So your name is Jimmy Gutierrez. Okay, Mr. Gutierrez, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
No.
Are you a United States citizen?
No.
Are you in this country with or without permission?
Without permission?
What happens if you go to jail, sir? Think. What happens if you go to jail?
I don't know.
Are you in this country with or without permission?
País pongo sin permiso.
Sin permiso.
Without permission.
What happens if you go to jail?
Probably get deported.
Not probably.
Probably.
The problem is you will wait in custody for 6 to 9 months, waiting for immigration to do whatever they're going to do. I'm putting conditions on your bond now. This is the only warning that you're going to get from me, Mr. Gutierrez. You violate any of these conditions, I will put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you as a condition of your bond not to drive any vehicle whatsoever. A car, a boat, a plane, a yacht, a motorcycle, no driving. If I find that you drive, I will be beyond upset. You will be signing a promise with me today. This is an affidavit that you're not to drive any vehicle, Mr. Gutierrez. We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria where we're going to have you sign a reset. After that, you'll get with Tracy for your bond conditions. And after that, you may leave. When you come back, have a lawyer. If you fail to show up back to court, a warrant will issue. You will not get any more PR bonds, Mr. Gutierrez. Please.
Page 15, Mendoza, Moreno.
Are you Eugenia Mendoza Moreno? That's right. Take your time, Liz.
I have a lawyer, he didn't come.
Yeah, we don't know when he's gonna get here. We're going to do probable cause. We do this with every single person that comes here. Ms. Mendoza, we're not gonna wait all day. And we don't know when he's gonna show up. They know we start court promptly at 9. You are now charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. And if you cannot afford a lawyer will be appointed to represent you, ma'am.
On January 23rd, 2024, officers conducted a traffic stop on a minivan for having a paper tag with inconsistent font and the Texas flag watermark was not billowing. The license plate check did not return a vehicle. The defendant was the driver and stated that she purchased the plate 2 months prior and that she paid $80 for the tag. She said she knows that you're supposed to register the tag, but was too busy.
Okay. Have you run her license to see if she has a license?
I'll run it right now.
Okay. Ms. Mendoza Moreno, I'm going to find that there's probable cause to go forward with your case. Are you a United States citizen, ma'am?
Yes.
You are a United States citizen?
She's showing on the.
I am,
Okay. Do you have valid liability insurance in your name? I'm ordering you not to drive any vehicle unless that vehicle is properly registered. Do not pick up any new cases, otherwise I will put you in jail. You will not get any more PR bonds, ma'am. For now, I'm gonna have you go to Victoria. We will have you sign a reset. After that, I will have you take a seat. Do not leave until your lawyer comes so we can speak to him. Please.
On page 16, Ortega.
Cesar Ortega.
He had a felony open warrant. He's in the back.
Oh. Sure.
Mendoza, Figma.
It's not screened.
Sorry. All right.
Judge for Mendoza, there were no bond conditions.
No, there are states conditions. Hey, Pavel, do you mind filing no driving without proper registration on Mendoza, please? So it looks like this gentleman was a probation transfer, huh? From a juvenile to an adult.
yes, sure.
And now. Good morning, Mr. Ortega. How old are you, sir?
Huh?
How old are you?
Ahora más, I just turned 19 this year.
Okay, I'm just asking, I'm just curious how old you are. Mr. Ortega, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine on that charge. The reason that we took you into custody is because you have an open warrant on your felony, you're on felony probation for injury to either a child or an elderly or disabled person. I don't know. They have since filed a motion to revoke that probation, alleging, and among other things, that number one, you picked up this case. Number two, you failed to report, and it looks like several other things. For now, we're going to do probable cause to see whether we're going to go forward with this case. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Your Honor, on or about June 23rd, 2024, at approximately 1 a.m, officers were dispatched to a disturbance. The officers made contact with the defendant and the homeowner, who were having a verbal altercation about some money the defendant had misplaced while shopping at a garage sale earlier at the location. The defendant was advised that he was trespassing and advised for him to leave the property. The defendant kept arguing with both the deputy on the scene, stating he wanted his money back. The defendant attempted to get the defendant to leave on his own, accord multiple times, with the defendant refusing and arguing with the officer. The defendant eventually left, but came right back while the officer was attempting to get information from the homeowner, and interrupted and stated he wanted his money back and he's not leaving. Defendant added the officer needs either to arrest him or he's going to punch the officer and make the officer arrest him. The defendant climbed a fence and hopped back onto the homeowner's property after the officer gave him multiple commands for him to stop.
Whose house was he at? I thought you said he was at his mom's house.
He was at
Yeah.
he was at a house that he had shopped.
Needs your help, man.
The homeowner was someone who was running a garage sale earlier in the day.
Okay, so he went to a garage sale basically, and he's
And he came back at 1 a.m. to because he misplaced some money.
1 a.m. he came back. Mr. Ortega, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with these people. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using illegal dope or any kind of substances, I will put you in jail. You will not get any more PR bonds. As far as it stands now, you're on bond for our case here. What's holding you is the felony case.
How much will my bond be?
With us, you don't have to, you're on bond as it is. You're at no bond on the felony case. So not until you get felony court will you be able to see what, if anything, that they put your bond at. But you're on probation, so I don't know what they're going to do. Let me ask you this. Did you graduate from high school?
Sir,
What are you doing with your life now?
what am I doing with my life right now?
Yeah.
Shit, I got 2 jobs and shit, my mama locked up. Shit, I'm the one that be putting money on her books, you know? And if I get locked up, then I don't know what can I say. That's why I look decent right now. I would just like to look decent, and, you know?
So let's do this. I'm going to give you a lawyer today. I'll have you speak to the lawyer.
Yeah.
My first mode of business with you is to make sure that you graduate from high school. So that's what we're going to do. And I'm going to keep you for as long as it takes to get that done. Do you understand, sir?
I'm even working on my Texas ID because, like,
I don't care about your ID.
yes, sir, but
No.
I can no longer be in here, you know? Cause, like, I need to feed my mama too. She's 58 years old and she's doing 25 years. And
Hold on, Mr. Ortega, please. So Tracy, let's get on this little gentleman here. Okay, no dope, no alcohol, no contact with the people and the homeowners. And then when he does eventually get out, because at some point, you're going to get out. When you do, you must come back to court here, and I'm going to put you on a plan to get your GED.
that's why
You
I came.
understand?
That's why I came out here to make things right.
I'm going to make sure that it happens, Mr. Ortega.
Me too, my friend.
Okay, so
Cause from right here, I was supposed to go see my probation officer.
we'll get there. For now, Victoria, if you can appoint someone, and then I guess in the next couple of days, we'll have them come back. All right. Oh, Tracy, no weapons as well. No, the felony court's gonna, I mean, I think they're gonna do that. And then we'll see. Yeah, go for it.
All right, page 17, Perez. Italia.
Do you speak English? How many PR bonds has Miss Perez gotten?
One DOB, one PR bond.
Take a seat for me in the jury box.
Do you want me to reach out to Nathan?
Yeah.
All right, Judge. Let's see. Page 20, Ross, come on up.
All right, good morning, Miss Ross. Ma'am, you were charged with a liquor violation. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay,
On March 12th, 2023, TABC conducted an underage compliance operation at Randall's. The cashier, the defendant, sold one Bud Light to a 16-year-old after briefly looking at his ID.
okay. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Are you still employed there, ma'am? What happened?
Prior to Sunday.
So are you working now?
I haven't been able to find work.
Okay, would you like to apply for an appointed lawyer, ma'am? Okay, Deputy, you mind giving an application? I'm gonna give you an application. I'm not gonna put any conditions on your bond. Just don't pick up any new cases. That's all we're asking, okay? I will have you go to Victoria, sign a reset, and then we'll have you take a seat in the jury box. We'll wait for a lawyer for you.
All right, Judge, that was our last arraignment.
Okay. Do we have THAs?
We do.
Okay.
Go ahead and sign for your receipt, please. All right, go ahead and have a seat in the jury box. Page 26, Williams, another arraignment.
You, Tanisha Williams. Miss Williams, you're charged with unlawful carrying of a weapon, where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On June 23rd, 2024, in Harris County, Texas, officers observed the defendant run a stop sign and conducted a lawful traffic stop. Officers approached the vehicle on opposite sides and observed a loaded black Glock 48 9mm handgun on top of the back seat in plain view, not in a holster.
Ma'am, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? You may continue to drive. Just be careful. Don't pick up any new cases. I won't put any conditions on your bond, ma'am. We will reset your case to give you time to hire a lawyer. So I'll just have you sign a reset and we'll get you out of here. And when you come back, please have a lawyer. Okay? Please, ma'am.
All right, go ahead and sign your reset, please. The Trinula. All right, there you go. You're free to go.
I want to see you better.
All right, Judge, you want to
There's a
see
cat in the
page?
tree.
Yeah,
Page 3. Top of page 3.
okay, Mr. Babode, come up.
What else that?
Other way, sir.
I still sign.
Sit all your property right there.
Mr. Hightower?
There's no problem. Just sit all your property right there.
Sir,
Good morning.
you have a lawyer today.
No, sir, I don't. I don't think I need one. Forgive me for saying that, but the original police report decriminates me. Can I read?
No,
Okay, okay, it's fine.
you need a lawyer to represent you.
Sorry, can't afford one.
What do you do for in life, sir?
So to give you background who I am, you can Google my name, come Kids Harbor. That's an orphanage. I don't have anything. I don't have no one. So please, sir, I cannot afford a lawyer. You understand that?
I don't want to talk about the case. I just want to know, do you work? What do you do for a living?
I just got a job, okay, and I have an apprenticeship. I don't make that much money, okay? Can't afford a lawyer. That's all I'm saying.
What's your apprenticeship?
Upholstery.
Upholstery.
Yes, sir.
How much money do you make a month?
I just started, but it's probably around 1,200.
What were you doing before that?
Subway, 5 years. At Subway.
Okay. And I guess you got fired from Subway? What happened?
No, I don't want to work past Subway 5 years. So what I look like. And I mean, I'm not trying to be rude, but working at Subway for 5 years, it does something to you. Okay, so I quit because I'm being honest. I quit Subway because it's 5 years of Subway. What am I going to do? You know,
I
can't blame me for that.
I agree with you.
That was. But I mean, like that's pretty much me right now. But if I can just explain, if you let me explain, can I explain the police report because it decriminates me, Sarah?
I'll give you a lawyer today.
Okay.
I'll have you speak to the lawyer. The lawyer can give your side to the DAs and then they can try to work something out for you. Okay? So just hang tight. I do need you to fill out an application for me. I don't know if I have one. Let me just check it out.
Be the prosecution.
Sir.
You're not allowed to
Talk,
talk.
okay. Because it literally decriminates me, sir. Okay.
Speak to the attorney when you get appointed.
So I need an application for you to fill out. Once you fill it out, I'll take a look at it. I'll grant it for you and then I'll have you speak to a lawyer here momentarily. Okay?
Same day or do I?
Today? Yeah, today. It'll be a while because we have to find one, but just be patient. But I'll have you speak to someone today. Okay? Stephen, do you mind giving an application? Okay.
So you're gonna come over
I
here.
mean, 5 years at Subway. What are you gonna do?
Sign for your reset, please.
Still got a piece of paper.
Yes, I'll turn it off.
I'm gonna try to see, but I like reading.
Sorry. Thank you. Go ahead and have a seat. Your primary advisor. Page 8, Dixon, come on up.
Personal protection, we'll send it to the jury box.
Mr. Kane?
Good morning, Mr. Dixon. Do you have a lawyer today? Oh, you have one? Oh, you said you're going to, or you have? Okay, would you like more time? Okay, I'll have you sign a reset. We'll give you more time and then just give him a call, please.
Go ahead and sign for the reset, please.
That would be me, the voice from above.
All right, Judge, page 60.
Hey.
Ovalle, come on up.
Hey, Vic, Victoria, can you help Mr. Goals? He's always, and who did you say it was?
Ovalle,
Oh, bye.
page 15.
Ortega, Cesar.
But you're not an attorney, correct? He's on. Okay, so he's hiring an attorney, Your Honor. The assistant is here. That's right.
Okay, so just go ahead, take a seat for me. We'll be with you
Cesar
momentarily.
Ortega.
Thank you, Stephen.
Yes.
Kane, like I can say Kane and you on the attorney record here.
Is that better or is it still low?
Yes, it was wrong. He did do everything should have been taken care of over the weekend or yesterday, probably.
Page 25. Girl, Stevie.
Is Salmaron on today? Hey, is Salmaron on today?
Yes.
She has bond violation.
She hasn't checked in yet.
Good morning, sir.
Morning.
Do you have a lawyer today?
I don't know, not yet.
What? Okay. Have you,
I was attempted, but the problem was last time I came to court, I had 2 court days in 1 week. So I got terminated and I just started the job like 3 weeks ago.
okay, we'll give you more time, sir. I'll give you another 30 days. Please start looking. When you
Yeah, I
come
will.
back, please have a lawyer, sir. Okay? Just hang tight. We'll give you another reset.
I can make it louder. I just didn't want to blow you guys out.
THA 30 days, please.
Go ahead and sign for the reset, please.
Wait, right?
He's dressed kind of subdued today.
In the queue, there's 2 bond violations. The first 2 bond violations, there's on conduct. We ended up revoking the bonds, and I forgot to put the bond amounts and sign the bail orders, or sign those bond violation, the BVRs. Are you okay if I do it now?
If the bond has been the bond.
Yeah, we did last week, and I just forgot to sign it and do it.
Okay, sign it, but put the date that it was done.
How do I do that?
So once you
Like,
sign
look.
it. Pulled him up the
So
other
this
day,
is
he's
here,
wearing like
so
a
like this one,
polka
the
dot suit.
25,
It was nuts.
2510130. So this one was revoked at 2,500. So I was gonna put here 2,500. So you want me to put here revoked? And then put the date? You want me to do it there?
I thought it would be able to,
Garcia,
because
come
you know where
on
it
up.
says sign, it should give you an option to change the date, but it doesn't. Just put the date there.
Where, right here?
Yeah.
So that we revoked it on.
Sign just a
6/24. So
Hold on.
Just put 6/24 since we'll. There you go.
yeah, okay. Okay.
Is it only one or two?
No, it's two of them. And then the other one's at 5,000.
All right, go ahead and sign.
Okay.
All right, there you go, you're free to go. Yeah, for Monday.
Do you remember Miss McSwain? She's the lady that was in the walker, threw a fit when we took her in that one time, she's kind of
Diana Sims?
Diana Sims.
Yes.
First off, Diana Sims never filed anything. Number two, she has bond violations. So
I thought she filed a motion to sell that same day. Or Shreya filed a motion to withdraw, maybe that's what it is.
no, she didn't do anything.
What's the case number on the check?
It's 2502375. What's that? She didn't file anything, right? Okay. So, yeah, you can have, come on up. Okay.
Have you all actually watched the Karen Reed trial?
You can have whatever you want. So as far as I'm concerned, Shrey is still on. Shrey was representing her. And then I think that we probably took Shreya off because we thought that she was going to file something and she never did. So, I mean, we should have.
Should have got her to do it that day, but she
Yep.
kept saying my
No.
office will file it. But I
Yeah.
thought-
Okay. So from now on, no more where the office is going to file anything. We should.
Especially when you have the paperwork.
Okay. So bottom line. Hey, I'm sorry to bother you.
Thank you so much, Lori. I
remember
really
Kristen
appreciate it.
McSwain. That was the lady that you were gonna get subbed out by Diana Sims with the,
Oh,
with the head.
oh, oh.
Okay. Diana Sims
on.
never filed anything. She's done nothing on it. So do you mind still staying on the case? If you don't want to, I understand. I'll just appoint someone else.
Hold on, I'm getting you audio. Just takes a second.
Deliberations. Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Tianetti?
Our view is that it's time for Tui Rodriguez, Your Honor. They've come back now twice indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. And it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encourage them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due in thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody? So why don't I take a recess?
Take a recess, please.
All right. And then Nancy.
Well, that's interesting. I don't think she's going to make him go back and deliberate anymore. I don't think she's going to be gone very long, so I don't really want to leave this. But I don't know that I have a lot to talk about. Wow. Wow. So that's that. That was 3 times they came back and said, we're deadlocked. Yeah, I agree. But if you have one holdout, there's some people who firmly believe that she is guilty and some people that firmly believe that she is innocent and that they are absolutely not changing their mind no matter what anybody says. And even though they sit in the jury box and they say, I will evaluate the evidence with a clear mind and no preconceived notions and no prejudice and yada yada, they do. Everybody does. You, even if you don't do it consciously, it's Excuse me. I'm busy. Could you not? Thanks. Okay. They agreed. You do. You bring all of your life experience with you. And even though you might not say, oh, yeah, I think he's a cop, so, it must be, he must not be a bad person. Even though you're not consciously thinking it, you still, if you have a positive view towards law enforcement, you think more positively. If you have a negative view, you think more negatively. It's just the way it is. What was the next? Oh yeah, he kind of wanted to keep going. Well, they haven't done long enough. But if I'll be interested to see what the numbers are. If there was only one holdout and everybody else was saying not guilty and there was one guilty, then it's pretty obvious if that person says, I am absolutely not changing my mind, there's no sense in waiting forever. When I was on a jury, we went in and instantly everybody was guilty except for one person. But he just said, convince me. You know, I have some questions. This is a man's life that's hanging in the balance. I'm not 100% convinced. And he just wanted to talk through the evidence again, which ended up taking absolutely forever. But we did it. And in the end, he's like, okay, yes, I do agree with everybody else. And it was just a matter of, he wanted to be extra, super, double, triple, quadruple sure of what decision he was making, which isn't necessarily a bad thing. Which one do you want? So it is hung. I mean, unless I misheard it, didn't she say that she agreed? Let's get him out here? Or am I wrong? Come on. Someone come here. I need a dog. Which dog? Come on. Come on. Okay, there's a dog. Wow. I tried to keep up with some of Emily Baker's recaps, but it was a lot. Okay, say hi. No, say hi over here. Over here. I followed it before the trial started, and once the trial started, it was like too many hours to keep up with. Can you say hi? Oh. Oh. Oh, that's right. She hasn't read the Allen charge yet, so she has to read the Allen charge. Thank you. She has to read the Allen charge, and they have to go back one more time, right? So there's a... I don't have the... I know. I'm impressed. Like, my fans wobble. How did they get it so straight? In a government building, no less. So in Mass, there's this specific rule related to hung juries where you have to, it's called an Allen charge, where basically you have to read this charge and then they have to go back and deliberate one last time before they can be declared a hung jury. But how crazy would it be if they go back one last time and are able to agree? That would be interesting. Yeah, you're up. There. Now they can see you. I know you're so tired. Life's so hard. Oh, you're so tired. Oh. Yes, absolutely. Absolutely. I call it like sensitive culture. Everybody seems like so sensitive to every little thing, and even when you don't mean things, like in a negative way, they still can find a way to take them so negative. Penny is full grown. She is 2.5. She was born 2/2/22. The birthday I can remember. 2/2/22. But speaking of movies, did you see that they are making a movie about this whole thing? I saw, what's his name? Aiden Turtle Boy posted it on Twitter. And then his ex-girlfriend or something like that posted something like right afterwards saying that they were making a documentary about her. and him. So I don't really know if it's the same one or if there's two different people. I'm not really sure, but there's definitely a movie being made that's going to feature all that drama from the protest side of things. We actually had a Who's Your Daddy stream. I got DNA testing done for Penny, and she is, I can't remember, like 24% King Charles, or Cavalier King Charles Spaniel, 75% Poodle, and 1% Bichon Friche. She's a mutt. She was supposed to be 50-50. And Ziggy's really a mutt. I can't remember what was his. Hold on. I might have it. While the fan is spinning. It's the only good thing about doing OBS. Everything else is harder, but you can actually pull up pictures when you need to. StreamYard is so hard. You can't pull up pictures in StreamYard. It's ridiculous. Although you can't pull up pictures when you can't find them. So there's that. Where would I have put that? Do. Maybe here? No? Well, I really don't know if I didn't put it there. Maybe I didn't save it? Did I not save it? That would be so bad. Well, at one point in time I had little pictures that said what their results were, but apparently I have a very disorganized file system, and I don't know where they are. It's that or I take way too many screenshots, so, you know. Either one. Either one could be true. One more place. One more place. Nope. Okay, no clue. Sorry. I tried. It's on my Discord, I think, somewhere. If you really want to see it. And then, all right, there's my chat back. Watermelon-shaped bug. Poor baby. Yeah, Ziggy's supposed to be like 5 pounds, but I think he's pushing 10. And the doctor told me Penny's supposed to be like 19 and she's up close to 25. We've been trying to go on a diet, but hasn't been working too well. Yeah. And I'm not convinced that it was an intentional cover-up, like, hey, let's frame this chick. Because that, I mean, that's just hard to wrap your head around. Like, how do you get that many people on board? Isn't there someone with morals somewhere up there in, you know, Boston? I don't know. Somewhere? Someone who says, hey, don't do this? Or that calls a higher up and says, hey, you got to put a stop to this? Like, I can see everybody dropping the ball and not doing what they're supposed to do. And I find it hard to believe that she hit him and killed him that way. That it just doesn't add up. I agree. Something's not right.
Court session, please be seated.
But I don't know what.
All right. So, jurors, I am in receipt of your note. Judge Canoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Judges, follow me.
You are muted. Goodbye.
Ceiling fan. I apologize. I misspoke just a minute ago. Alan is not unique to Massachusetts. I've just never heard it. I don't know why. I guess not a lot of hung juries. Okay, so the Allen charge is also referred to as dynamite nitroglycerin shotgun, or third-degree charges, and it refers to a jury instruction given to a hung jury which urges them to agree on a verdict. Allen charges are controversial, and some claim they overly pressure parts of the jury to change their opinions and to cave to peer pressure, especially on minority opinions. Because of this, many states do not allow Allen charges, but the federal courts may use Allen charges. The name Allen charges come from Allen v. U.S. 1896, where the Supreme Court ruled that these types of jury instructions were allowed in federal courts. That's probably why I never heard of it. So, Mass is one of the states that does look at it, and there's quite a bit of debate over it. And I can see why. On one hand, if someone is being a pighead and stuck in that no cop is ever guilty type of thing in that specific circumstance, they need to come off of it, obviously. But on the other hand, if someone is solid in their, I really don't believe this, it could push them to cave to peer pressure and vote a way they're not comfortable with. And that's something they have to live with for the rest of their life. That means we'll be here a couple more hours. So, I guess where were we at? Let me get you Judge Fleischman back. Poor little ceiling fan's putting in work. Where is the ceiling fan? There's the ceiling fan. We're gonna mute the ceiling fan. And then we are going to
really bent over backwards to help him. But I'm telling you, he comes when he wants to come. He does what he wants to do. He has no respect for authority, and he has no respect for the court system.
So respectfully, Judge, prior to, I wasn't his attorney on the last case. His family has hired me. He did have a major brain trauma, for which he had to go through significant rehab. I would, and again, I don't know the history. I just do know that in 2020, somewhere along there, he was.
What needs to happen is just gather all the stuff you need to do to get to the state. Because I don't feel comfortable giving him another PR bond, because for me to give him a PR bond, I have to put conditions on someone. And I know when I put conditions on him, he doesn't give a rat's behind about our conditions, about our bond. He doesn't. I have multiple bond violations. I try to get him here to address it, and we can't. It's a futile attempt. So I would have get him here, put bond conditions. He's gonna get out of here. He's gonna still do whatever he wants to do.
So can we approach tomorrow with a bond so we can do a walkthrough so that he is not having to, we will be back tomorrow and we will do a walkthrough. So he's not having, because he's on a walker, it's just a lot to try to get him into custody.
But yeah, then again, no, I get it. But again, he's gonna post bond, he's gonna get out of here, he's gonna do whatever he wants to do.
So I'm going to, with the court's permission, the state's not opposed, I'm going to apply for him to be admitted into Veterans Court, where I think they can help him navigate the VA program. He is currently going to Narcotics Anonymous on Reed. And like I said, he's trying to get into this other program at the VA. So I understand the history. I can't speak to that. I can only speak to my interactions with him over the
Ms.
last
Cockrell,
month.
the only thing I'm gonna do is, and I'm gonna do what I do with all my other, I guess, high maintenance clients that have pill and abuse issues with that, is I'm gonna have him come on a bi-weekly basis here to court to come test, right? So if he comes tomorrow, I'm gonna have him come. I'm telling you, I'm gonna have him every Monday and every Thursday. I'm gonna have him expected to come here to court to test. The first time he fails to appear, I'm done playing this game and I will take him into custody, but how many, do you know how many lawyers we've gone through this with?
I do, Judge, I do. Is a scram device not possible for him? And the reason I ask is because.
He doesn't, I did it last time.
I understand, he wasn't, Judge, I understand, I'm not trying to be disrespectful to the court, but he lives in Pearland beyond, in, I forget what it's called, something village. And so it's a $47 Uber or Lyft for him to get here.
It's always one thing or the other. It's always, I live too far. I have a walker. I have to go to the VA. I've got to go get this work. I've got to go see my counselor. In the 4 years we've had this case, it's always one thing or the
I haven't
other.
had the case for 4 years.
I get it, but tons of other people have.
I understand.
And I don't know how inclined I am to do. I mean,
I just think it's cost prohibitive, unfortunately, I think, for him to get from his home to here twice a week. I just don't think he has that kind of money. It's coming here is $40 and then going back is $40. And I understand the court's desire to monitor him, but I think, if he.
and then you know what? I mean, this case is 4 years old. I'm ready to set it for trial. I can't even, if he's not willing to abide by the terms of what we're gonna do, and he's not willing to do that, then I'm just gonna set it for trial. I can't, Ms. Cockrell, at some point, we become enablers,
I understand, Judge.
right? And now we're at that stage where I'm enabling him.
I understand, Judge.
It's not fair to everybody else.
You would
I don't
give me an
know.
opportunity, a month, I'll bring him in tomorrow for bond conditions with a bondsman and give me a month to try to get him into Veterans Court. And then if not, then you can set it for trial or we can dispose of it.
No, so I'm not gonna, so what I would propose is that I'm gonna go ahead and set it for a month for trial.
Okay,
That way it'll get him hopefully the spilkis and the tukis to get it to work. But I'm telling you, I'm still gonna have him drug test 2 times a week. I don't trust him to do it on his own. And if he wants to wait a month, he's gonna have to put up with the bond condition.
I understand, Judge.
Given the light that the case is 1,300 days old and it's,
If he's being tested in this program, are you willing to accept their?
no, because I don't trust him. I don't know who's doing it. It could be Punka City testing. I have no idea. I don't get wind of it. I don't know who's doing it. Yeah, but at least with our people, I know. And the problem is also having him come, having him see me, having him see, right.
We'll be back tomorrow, Judge.
And, I know I shouldn't be, but I'm sorry that you're in such a tenuous position. But sometimes as lawyers, you walk into just a complete, what's the word? Just
Not the case. Cluster.
S show.
You know what I mean?
Yeah.
And understand that I appreciate your tenacity and I can't enable him anymore.
I understand.
We've been doing it for 4 years. Okay,
We will be
so
back
just keep me in the
tomorrow.
loop.
We'll be back tomorrow.
Yeah,
Thank you,
for
Judge.
sure. Hi, hey Dion. Hey,
Looks like you just came from some,
yeah,
a nice holiday.
with the kids. What's up?
Trip, not vacation.
Yeah, no vacation.
I'm
way.
here, Mr. Robert Sanchez, is to expire his PTI, do you have a PTI on the 18th? He will be done paying his fees this Friday.
Is he here? Do you mind bringing him up?
Mr. Sanchez, go around that way. He'll be done this Friday paying his fees.
Okay. Is that, Shatori, is there anything else Mr. Sanchez has to do?
It's just the fees,
That's it? How much does he owe?
$520.
He's not to expire till the 18th, but he said he'd have it done this Friday.
Okay. You'll have it done by Friday?
Friday, yes, sir.
Okay, so let's set it off to Friday. then.
I won't be here Friday.
Do Monday?
I'll check my calendar. Oh, can we, if he just pays it, wouldn't it just be dismissed off docket?
Yeah, but we still need him here in the event that he doesn't. What if he doesn't do it?
I know we will.
I'll
Until
do it.
Tuesday, and that way if it clears,
Okay, I'll reset it to Tuesday because I have to put a reset date on it. I
Understand.
can't just keep it in
Well, he
limbo.
has one, the 18th. He doesn't expire till the 18th of July.
Let me see. I have here the next court date was June 28th of 2024.
Yeah, I was out of touch, July 18th. That's when he expires, is July 18th, that's what the contract says.
It's weird.
We all tried to bring it last Friday, I was out of town, so we did it today because I couldn't physically be here.
Oh, yeah, that's weird because the supervision order says July 18th, but
Right.
the reset says June 28th. Yeah, hey, Victoria, on Robert Sanchez, the reset says June 28th, but it should be July 18th. Can we do a reset to July 18th?
So yes, we can, but when they send me the emails for a 3-month extension request, I don't wait till the end.
Right. Okay, so we'll give you the reset to the
The 18th.
to the
Yeah.
18th.
Yeah, and have it done.
If you have it done beforehand, then, if you don't have it done by the 18th, you must be here at the 18th.
Absolutely, yeah, have it.
Makes sense.
He's always, okay, thank
All
you.
right, guys.
There you go. You're welcome.
Yeah, but at least you can get a signature now, just in
Yes,
case.
yeah.
Hey, Pavel?
Yes.
Come up real quick.
Sure. Got it. Oh.
I know, right? Sheesh.
It's cute.
No, the way you grab it. That's
Seriously.
Oh,
Crazy serious.
sorry.
You have any more THA?
No. But Rob's,
Okay.
is that on Rob's? No, the Bernie. Are you gonna have that?
Huh?
Yeah, he
I'm
grabbed it.
gonna appoint him.
Yeah,
It's just the,
I love his drawing on the parrot.
I know.
the parrot's good.
Yeah,
You did a
it's
good
got some
job.
good detail there.
So, yeah.
Yeah.
Thank you. Do you wanna talk to him or do you want me to just give it to him?
I'll keep it.
Yeah.
Where's Mr. Hayes?
Mr. Hayes.
Coming up, sir. Shatori, so we're sending Mr. Hayes now?
Okay.
Okay. All right, sir, I'm gonna have you take us into the jury box. We're gonna send you real quick, okay? Thanks. And then if you wanna, I guess just come back with like in an hour? Are you okay with that? You can always zoom in too. That's an issue too. Okay, thanks. Someone broke my pen. I know.
You just have it up there?
No, I have it in here. Someone broke it. I know. You know, we need to fix this. I know.
GED. You set him for today to show proof he's working on GED. He did enroll in Lone Star College.
Let's see.
These were the prerequisites he was supposed to do. He did a test for them recently. It says level D. I don't know if that's his grade. I don't think it is. But then it says for one of his grades, it says 587. I don't know what that is. And then the other one, it says negative 540. I don't.
Where is he?
Sorry, Judge?
Is he here?
Yes, Judge, he's here. Mr. Calvillo? You go around this way. So I don't know what, he said those were the prerequisites he had to take to get started on his GED, according to Lone Star College.
Hey, Mr. Calvillo, how's it going?
Good.
So tell me, how's this going?
It's not too bad, pretty good.
Shh. So tell me about it. What happened?
Basically, I went to Lone Star College.
Okay.
And I took the test on computer to see where I was
Where
what
they
I
would
need.
place you, I guess, right?
Yes.
Okay, and?
And basically, I'm doing good. I just need help in math, so I'll be taking math classes soon.
Great.
Yes.
So are you scheduled to do it now?
Yes.
How often?
I have to be there July 17th.
Just one day?
Well, I'm doing like an orientation, I'd say, like.
On that day?
Yes.
Okay.
Yeah, so they'll tell me what's going on with where I'm at.
So let's do this. Why don't we set it for just a couple days after that? I want you to bring your schedule because I want to see what you've done after orientation. I want to know what classes you're taking and the schedule. You understand?
So I'll have to come back because like right now I'm kind of unemployed and like I got child support too and like I'm not able to get a job because of my background, so it's like a process.
Well, we'd have to still talk to the prosecutor about working out your case.
This case is still open, Mr. Calvillo. It's not done yet. So, and if you owe child support, you have to get a job.
Yes, that's what I'm saying. Like I'm unable to get a job right now because the case is still open.
No, baloney. There's always a way to get a job. It's right here.
I've been working, like I went to Rosenberg, remodeled a couple of restrooms and bathrooms, so it's like, but the money is not that great,
So what you need to do is this. Hold on a second. Let me look here. Your record is not that bad. There's nothing there that should prevent you from getting a job. So what you need to do is you need to go to Amazon. Amazon starts at about $18 to $20 an hour getting on. It's really, really good, right? The pay is just phenomenal for people without any kind of education or whatnot. So this is the most important thing in your life. This and the child support, because your kids need to eat and they need clothes, right? So you have to get a job and you have to finish getting your high school diploma. I want to see it. I'm not going to take your word for it. So the minute we leave here today, I want you to get on the computer. I want you to find out going to Amazon to try to getting a job with them. You understand? I next want to see you within a couple days of the 17th to see what you've done for your GED and classes. If you've done nothing and you come here without paperwork, Mr. Calvillo, it's not going to go well for you. Do you understand?
Yes, sir.
What I do now is I document everything that you and I talk about now, because I will most certainly forget it. That way, when you come back here, the 17th is a Wednesday. So I'm going to put you on for the 22nd, which is a Monday. I want to see what you've done to get a job and for school. Do you understand?
July 22nd, Judge?
July 22nd.
Is he excused, Judge?
Yeah. Here. Yeah. Okay.
I'm gonna get you a new court date. Thank you. I have one more, Judge, whenever you're ready.
Give me 1 second. Let me just notate this real quick.
What's the name?
Next one I'm talking about, if you need that.
Okay.
Judge, next one I'm talking about is Quacarius Scales, last name Scales. Ms. Link has given us an offer previously that she'll dismiss both misdemeanors if he enters felony PTI. He has he's set to enter felony PTI August 12th, and he has a T-kit. That's the only reason why he couldn't already, Judge, is because he has to get his TRAS done. And so they have his TRAS set for around July 20th.
Okay.
Can we set him to August 12th for dismissal? Because he's going to be entering PTI then, or maybe the day after to confirm entry.
Okay, I'm okay with that. If he's not done by then, it gets set for trial though.
Can we do the day after to confirm entry? All right.
I'm telling you, if he's not done, if he doesn't enter it and he tries to play games,
Yes, Judge.
I'm setting it for trial because it's just way too old. We're now at 194.
Yes, Judge. I think it's all going to work out. Thank you, Judge.
Okay, thanks.
Okay, I'm approaching on Vidalis, Brandon Vidalis. Sure.
Hi there.
Hey, Judge, how are you?
Hey.
I've got a guy on the docket today named Brandon Vidalis. He had, and that's a VIDALES.
Is he in jail or?
He's in jail. Apparently he had a case and then picked up 2 new cases. May have some issues, some 1622 issues. I might need to file a competent psych exam on him.
Able to communicate with him or no?
I can communicate with him. It's just, mixture of might not be quite right and may want to be.
Well,
I guess we're approaching on the 2 new cases in terms of.
I guess I'm willing to. What would you like?
What would I like?
Yeah.
I mean, I don't know if you want to mirror what was already on the trespass case. What's the bond on the trespass case? Just mirror that, maybe. Yeah. Okay. That sounds good, Judge.
All right. Thanks. Whatever you want. Okay. Slider on.
Let's go, Judge.
Mr. Goins.
Good morning, Your Honor.
Hi, bud.
I didn't want to turn off this phone. Don't want it going on. Anyway, now, Mr. Marcus Johnson, we have a motion to withdraw. And I've called his name several times.
Did Marcus Johnson check in?
Marcus Johnson, Your Honor, is in the back. He's in custody.
In custody?
Oh, he's in custody. Do you want to go talk to him?
I'll go talk to him. Yes, I will. We have a motion to withdraw. I guess his family's not paying us.
Let me just make sure. His bond in our case is set at $75,000.
Wow, on a misdemeanor?
On a misdemeanor. It must have been from the magistrate. I don't know.
Violation of protective order is one of them, and let me
Yeah,
see.
do you mind bringing him out, please? Give me, Mr. Goins, if you want to withdraw, I'm okay with it. And we can just appoint him someone if you want. It's up to you. If you want to stay on it, you can. If not, we'll appoint him.
No, we're gonna go ahead and withdraw and let him get a court-appointed lawyer. So you have someone that he feels is Yeah. Yeah, I've been on murder cases for 40,000 murder cases. God, really.
Yeah, I don't know. And it looks like you've, or your office filed a motion for a bond reduction in May, but I don't think anyone came and approached on it. So it just kind of sat there.
Well, I'll tell you what I'll do, or at least represent me on that. I can at least see if we can get a bond reduction and then withdraw. What about that?
I don't know what happened. Let's see what happened and we'll go from there.
Okay.
Pavel,
Yes.
what's your opinion on a bond reduction?
Judge, on a case like this, the allegations actually arose. The allegations on the violation of protective order arose less than a month after the felony was picked up. He is habitual, he knows that, so, the bond amount on the felony is 50. And if the court were to issue a reduction as they would request, something along the lines of the same as the felony, which is 50.
Okay. Ms. Garza, would you let us know what happened in the violation of protective order, please?
On March 14, 2024, in Harris County, the complaining witness went to the Harris County Assessor's Office. While waiting, the complaining witness saw the defendant. The complaining witness ran out of the office where the defendant followed her to the car.
That's right.
The defendant said, "I'm gonna get you, motherfucker." And the defendant is on bond for assault of a family member with previous conviction. As part of the bond conditions in that case, the defendant is not allowed to communicate with the complaining witness in a threatening or harassing manner.
So he actually doesn't get to her, right?
No, he verbalized it directly to her, but he does not assault her anyway, in the violation of protective order.
And in the felony assault case, is it impeding breath or how bad?
Judge.
I will definitely give you a bond reduction. Thank you. Mr. Johnson, I think the bond is a bit excessive. However, understand that so he is a true habitual upstairs?
Yes, looks like Judge striking with the hand, so there's no allegations of impeding breath.
Okay, so you're facing up to a minimum of 25 up to life, up to 99 or life in prison on the case upstairs with ours. What would you like as far as a bond reduction?
Was $10,000 now at the most.
You said 50.
Yes, sir.
So I'll split the baby. I'll do it to 35. And that kind of cuts this one in half anyways. I still think that's excessive too, man. You know?
Well, the court ultimately it's your bonds, Judge.
Yeah, I mean, I'll give you what you asked. I'll give you 10,000.
Thank you.
Mr. Johnson, understand that you're not to have any contact with this person. And I'm going to tell you now, and I think I've already told you before, but the Texas Constitution does not allow me, but in very, very limited circumstances, to hold someone at zero bond. This is one of those instances. If you are charged with the violation of a protective order and you violate any of the conditions, I can have a hearing to hold you at no bond, and I will do it in a heartbeat to protect every single person of Harris County.
Yes, sir.
Do you understand?
Yes, sir.
I don't know whether you're going to be able to make the bonds on these cases or not, but if you do, one of the things I am going to order you is to have a GPS monitor prior to release. I got to figure that the felony court is also probably going to do something similar, and no weapons and no contact with the complaining witness.
Yes, sir.
As far as its counsel now wants to withdraw from the case. And so you do want to withdraw, correct?
Yes.
Right. And I imagine because they're not getting paid, right? So what I will do is I will appoint your lawyer today so that you do have someone to talk to. Is there an offer in the felony case now?
25 years.
They've offered 25.
Yes, sir.
Okay. And if he takes anything upstairs, okay. So they've offered you 25 upstairs. I don't know what you guys are gonna do upstairs. They have offered for whatever you do upstairs to dismiss this case down here. We'll wait to see what happens for now, and then just we'll keep us in the loop and we'll keep you in the loop for whatever
Okay,
happens.
can I ask like about the big, no, okay.
Any questions?
I don't want to talk about the case. I've got a bunch of DAs here and everything you say, they're gonna sit there and type it and use it against you. That's what's, it's best really just talk to your lawyer. They can answer your questions. If it requires DA input, the lawyer can always do that for you. But regardless, I'm taking them off now and I'm gonna appoint you someone new today. And then we'll have them come talk to you momentarily, okay?
Thank you, Anna. You have a good day.
See it. Oh, no, but counsel,
Yes.
we need you to file a motion to withdraw.
I think it's been filed already.
I don't see it.
I didn't
This
approach
doesn't
them.
see it either. So if you look in the tower, we may have one in the tower right over there.
I sure will.
Mr. Goins.
Yes.
We have one right there.
Okay.
Andy.
Judge, we have 3 DWI time served pleas. You want to knock them all out at a time, or do you want to do one at a time? All time served, please.
Okay, bring them all up.
All right, okay. Mr. Carrier, Mr. Blanco, and Mr. Gonzalez, please approach.
All right, so let's go in order. Mr. Blanc?
Yes, this is Mr. Blanco.
Blanco.
Mr. Carrier, you can go next, and then let him be in the middle. You're right.
So Blanco,
Carrier,
Carrier, and Gonzalez. Guys, all of you are charged with driving while intoxicated. You've all entered into and worked out an agreement with the state of Texas. It's called a plea bargain. And the bargain is that number one, you're not going to jail. But what you must understand is these charges will go on your record. They will be there for the rest of your life. You will never be able to take it off. Do you understand, or would you like a translator, Mr. Gonzalez? You understand what's going on? Okay. What you really need to understand is that from now on, if you were ever pulled over in a car, the first thing an officer does, they're going to look up your criminal history, because they do that on every single person they pull over. If they see that you have a prior DWI, they're going to harass you. They're going to search you. They're going to do everything in their power to look to make sure that you are behaving yourself on the road. And if you have even the remote, small smell of alcohol or dope, what do you think is going to happen? What do you think is going to happen? What do you think is going to happen? Right, right, and right. They're not going to let you go. They're not there to be your friend. They're not going to pat you on the back. Okay, come on, you can just go home. Just go right home. They will charge you with a second offense. What we're doing today will not happen again. From now on, you are facing a minimum of 30 days in jail. And if you're not smart enough to consider how to get home on a night of drinking, then like the children you are, we will put you over our knees and spank you with a ton of jail time, just like little children. Think before you act, think before you speak, because if you get into a car with even the faintest smell of alcohol, for the next 5 years, you're going to come back to me. And I'm telling you, it's not going to be a pleasant ride here. Do you understand? For 15 bucks, all you have to do is hit one button and you have a car willing to take you on Uber wherever you want to go. 15 bucks. It's a damn geographical oddity. 15 bucks will get you anywhere in this city, no matter where you want to go. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you were stuck with this. You can never change this. You can never undo this. There's no buyer's remorse like Target where you can return it. Do you understand?
Yes, sir. Yes, sir.
How do you plead to the offense of driving while intoxicated, gentlemen? All of you are facing up to 6 months in jail. However, you've worked out an agreement where they're offering you 3 days in jail, credit for the 1 day. I'm going to suspend each of your licenses. Mr. Blanco, I'm going to suspend your license for 90 days. Do not drive until you get a license. Mr. Carrier, I will suspend your license for 90 days. Mr. Gonzalez, I'm going to suspend your license for 180 days. Do not drive until you get a license. Like I said, all we want are our streets to be safe. And now with the DWI on your record, every time you get pulled over, they're going to harass you like crazy. Don't give them the right to do it. You understand, guys?
Yes, sir.
All right, good luck. Please see Melissa.
Judge, my last case is Mr. Taylor, who's in custody. Judge, this is a VOP upstairs still pending. That's the felonies reset till.
What's the last name, John?
Taylor.
This is Danny.
Yeah.
Danny, Danny Ray.
Of course, you know, Pav and I have already talked, and this will go away if.
I know.
So do you want to just bring him back in 30 days? Do you want to like one after, or do you want to, it's your call, Judge.
September 18th is the next day, huh? What's gonna happen on that day?
We kind of looked and it's kind of hard to say, Judge.
I mean,
it's a little more, it's, you know, I mean, we can bring him back one day in August, 30 days, like early August, and check on it. I'll call upstairs and see what's going on.
yeah, let's do that. Right, and
You
then
got it.
I'll give you one final reset after that, but after that.
No, I got you, Judge.
September date, if they don't do anything,
I'm.
Judge, on Marcus Johnson, do you want me to amend his conditions to GPS prior to release?
oh yeah, oh yeah. So on Johnson, GPS prior to release, no contact, no weapons, no dope, no alcohol, and
Judge, can you check your waiting room?
check my what?
Waiting room?
All it says is admin. Do you know who that is?
Maybe that's Mr. Gift Tacos, but I'm not sure.
Hi. Good morning.
Morning, Your Honor. I'm Matthew White, intern with the Federal Office.
Good morning, Mr. White.
You're with Alan Williams on behalf of Commissioner Jones.
Jones.
Yes.
Custody on bond.
She's in custody, but in the holdover right now.
Okay.
We're trying to reset her case, but she's picked up another.
Okay, give me 1 second. You said Keisha Jones, right?
Yes, sir.
So we have her on assault 3501. She's now picked up an aggravated assault.
Yes.
They gave her a PR bond here. That's cute. What happened to the assault?
Ronaldo
She
Perez?
shoot someone? But hopefully not.
She did hold a knife approximately 16 to 18 inches long to the same complaining witness in our court, but officers were initially dispatched on disturbance, weapon call,
She put a
and
knife to the dude's throat?
not to the throat. She was just threatening them and swinging the knife.
Your Honor, she do have schizophrenia. She started taking her medications again while she got here.
Well, that's the problem is always gets it when they get here, but as soon as they out the door, it's no more. And then it's, yeah, okay. So no PR bond, right? I'll leave it as is now at the 3501, but I'll just won't, no more PR bonds. She's ready to give it. I mean, I think that's number 3. Let me see.
That would be number 2 in
2.
Harris County, and then out of county, there's battery in Louisiana.
Okay. So she's set for 8/13. Do you want the day after?
Yes.
Okay, we got you. Yeah, I can't, not when you pick up she's. I wonder why they didn't file a VPO, you know? But, and it is what it is. Yeah, okay. Hey. On Jones, Ixnay on the PR bond A. On, yeah, I did, on the dude that's in custody. I reduced the bond substantially, so he may bond out, I don't know, but if he does. You tell him that if he wants to come out, he's got to put his clothes on.
I wouldn't bring him out like that anyway,
Well,
but I'll let him know.
If he wants to come out, if he wants not to go in jail, put his clothes on. Really?
Period.
I mean, that's not a good response to anything. He came up to here, and he's trying to give me stuff directly. And we told him to wait in the jury box while he's doing his application, and then he comes like barreling up here. So he took him back. I don't think it's that.
No, it's not that bad, but I will tell you, there is definitely some issues, but I haven't seen anything legal.
I agree. So he says he has a reason. If I remember correctly, this is something where he was working for a carpet company and ended up allegedly keeping some of the company's equipment.
Yes.
He called them and told them, hey, come back, return the stuff, or else. He didn't go take it back, and so they ended up filing the theft charges, right?
I talked to State of, not quite right about you.
Shh, it's so loud in here.
Can't figure if it was gone.
Yeah, I don't know. That's
where we are. They're gonna contact her.
Right. Okay.
You know, in terms of the claim is whatever.
You ready?
That's where we are.
I'm giving him a chance to compose himself real quick.
Okay. I'd like to talk to him one more time to try to get him to calm down, and then I'll give him, you want 30 days?
30 days.
For sure. Never a dull moment.
Ryan, so sorry. I'm so sorry, sir. I don't know. I'll behave, I'm sorry. Oh, you tried to smile a little bit.
Oh.
I saw that.
You know what I say about composing
Okay, sorry.
yourself?
I'm just trying to be nice.
Right. But nice is with actions as well, right?
I will compose myself properly, sir. And I would like to apologize to everyone in the court. I'm sorry, I'm trying to.
Stephen, just.
No. Can I say so? I'm not trying to do that.
You know, first like this.
I'm innocent. I am innocent. Read the original police report. I am innocent.
Calm down.
I am innocent. I will not comply with this.
If I may, are you letting him?
I'm gonna let him out. I just need him to calm down and he's trying to do whatever he wants to do, whatever, you know? No. I want to let him out today. Let's just give him another 30 minutes. Just. Give him 30 minutes and then hopefully we can.
Well, we'll try it again.
I'm gonna run to 228, do some conditions for real quick.
Okay, for sure. Thanks, Trace. Okay. So on Jones with the ag assault with the knife, what exactly did she do? Did she try to stab? Was she just waving it crazily? What? Because I'm doing a bail order and I need to justify why. So what exactly did she do in the ag assault? Please.
The complainant said that when she got home, she went up the stairs and her daughter arrived, the defendant, and came out of the apartment, starting swinging at her with her hands, trying to strike her in the head twice. I say that in one hand, her daughter was holding a knife approximately 6 to 8 inches long. The complainant went and stepped down and then ran back down the stairs.
Okay, hold on. So as soon as mom got home, she started swinging and attacking the complaining witness, and then
Swinging towards her head and face, and then in one hand, she had a 6 to 8 inch long knife.
okay,
And in that case, the defendant did admit to swinging her hands at her mother with the knife. Because she thought it was funny.
is what?
Because she thought it was funny.
Okay. Okay, sorry to keep you waiting. You want to come on up? John,
And then we're talking on Zoom.
what's up, friend?
Judge, can we start with Mr. Calvin Douglas?
Sure.
From the docket. He was reset thanks to the court because I was out last week and Your Honor reset him to today.
Mr. Douglas?
He's doing well. He's in contact with me. Your Honor.
He's supposed to be here.
He's here.
Okay.
And Your Honor had set a bond condition. I think you wanted him to check in to see how he was doing, and he showed me all these flyers from the Workforce Solutions for the employments he's going to attend. Some of them are in the future.
Mr. Douglas, come up.
And he's got an employment application, so a copy that he's submitting for Intercontinental, so he's trying to secure employment.
Another big, oh, well, no, that one's not. There's a big workforce solution for CPS people, but
From what I'm gathering, Judge, he's actively trying to comply with that condition.
so tell me what you've done, Mr. Douglas. When is that? When is it though?
I think he said he had an interview, Judge.
Oh, and how'd it go? Okay. You can't just sit there and wait and hope and wish and pray that they're gonna, you gotta keep putting in applications, you gotta keep going to places. Have you gone to Amazon yet? Okay, have you gone to apply with Amazon yet? So is there another workforce solution coming up, or is that it?
What he showed me is he's been to some of these events and there's a few that are coming up. Next week is another one. So yeah, July 8th, 9th. So I mean, they're basically every week, Judge. So I'm sure he'll keep looking if he doesn't hear back from the city.
Okay, let's set this off 2 weeks, see how you get, Mr. Douglas. Okay, I want you to keep looking. I want you to get a job. This isn't something where you just sit there and wait. You have to put in application after application, go to place after place until someone eventually will hire you. They need workers. So keep at it. You will get a job. And when you do it, you have to put your heart and your soul into the job, because that's the way you get better at things. You can't just be half-assed, because you won't get anywhere in life. Okay, Mr. Cedillo, take a seat for me, Mr. Douglas.
Thank you, Judge. Next, I've got Miss Augustine, last name Augustine, first name Abilene.
Okay.
Well, this is another one that I think we reset to today. And she, Your Honor,
This one's for a GED, right?
Yes. And the state has made an offer, so we're discussing that with her. And
what offer have you got?
Basically deferred, Judge.
Okay.
And so we'll see.
Has she done anything to get a GED?
So we've been in contact with her professor. The class that she was going to enroll in is booked until I think the re-enrollment is middle of next month. So she's she cannot start right now, but she's made efforts to get into the next enrollment session.
Have you gone through the MAC to see? Because they have social workers.
I have not, Judge, because last time when I appeared a week before my vacation, I did not know that was the condition. So I'm barely back today. So and my staff has been in contact with the professor who said she's going to enroll. So if that falls through, I'll go to the MAC. But it sounds like she's got a good lead on getting back into class. It's just class is full.
I'm not going to take anything in this case until she starts doing GED classes and starts getting her GED.
Right, Judge.
I will not take anything.
Okay, but
So-
I think we independently verified that the class is currently full and she's in line to get the next, be in the next session. So
Here's the deal. They also, through the MAC, have workers that will get them classes, help them get into it, and they pay as well, don't they? Yeah.
No, Judge, my client just did, they gave her a cheap service, $150, and it's a full G, and she was able to pay.
I'll definitely look into that. I'll email the MAC today and see if that's a better option for her.
Please, because I think that, that for that price, which is pretty cheap, gets them into the entire program. So they end up with it for $150, they end up with their GED, which is just super cheap.
I'll definitely look at that option, but she is also trying to comply with that condition, Judge. So she's on top of it.
Okay, so by the next time, I want to see if she's not done, because I'll set you off for 30 days. If she's not in that, then this is the route that we're going to take.
Sounds good, Judge.
Because now 2 months have passed without her doing nothing, just, and
Right.
unacceptable. So
Well, I mean, she was contacting her professor. I just don't know the details of.
it's okay. It's all right. So, and I get sometimes it takes a bit of time and I'm okay waiting for it, but I want to make sure that it actually happens.
Got it, Judge.
All right.
Thank you, Your Honor.
Sure. You say, John, that she knows the professor? Is that what the deal is?
Yes, Judge. Yeah.
How do they know each other?
I'm not sure, but she had already had a contact and my staff has been following up with him to verify what she told us. And they said, yeah, I'm trying to get a letter from him to show the court, but
30 days, it will open up a position for her?
that's what my understanding, and I'll double check with her.
Got it. Sure, thank you. I'm documenting everything, that's why. Hunter,
Hey, Judge. I'm approaching on Cecilia Samara.
is she here?
Judge, I just got a text from her.
She's supposed to be here. She's not here, and there's a bond violation. I'm issuing a warrant. That's it.
That's right.
Okay.
But
What else you got?
I'm gonna tell her to be in court tomorrow.
Can, whatever, but she's got bond violations. I'm not happy
I
with
completely
her.
understand.
Yeah, okay, thanks. Sure.
I just sent you an email regarding Salvador.
Hold on, Connor, hold on. Hey, what's your email?
CONNFLAN
I got it.
94.
On flag 94?
Yeah.
I'm forwarding this to you.
Got it.
All right,
Thanks, Judge.
thanks. Thank you, Tracy. All right. Tim,
Good morning, Your Honor.
good morning, sir.
How you doing this morning, Judge?
Sorry to keep you waiting. You know, we have a lot of people that try to get into the Zoom, and when we don't know who it is. Okay,
I have no problem. Plus, I got a very easy one, Judge, maybe a half a minute.
Jeff, talk to me.
Yeah, I've got our own Vergara Quiros, case number 2508982. 2508982. It's a motion to retrieve, unopposed motion to retrieve property. We okayed it with the DA's office. The case was dismissed for lack of probable cause by you. And I'm trying to get the the firearm back. And basically that's all I need. I filed a motion. I have an order before
I
you.
see it.
there.
Okay, do you see it?
Your-
He
Your Honor,
filed, so I asked him to get proof of purchase and
Yes.
it's uploaded in the system and I see
filed
it.
it, Your Honor, we
I
sent
see it. Okay, I'll grant it for you, Tim.
Thank you very much. I do appreciate your time this morning.
You got it.
You have a wonderful, wonderful day. Bye-bye.
Do you need the cost number? Are you ready? Yes. 2508-982. It's a motion to restore. You can put it in the queue. Okay, we got you.
Thank you, Your Honor.
Thank you, sir. Eric. Hey.
Last name Quick.
Chop me in my pinky toe. All right, tell me about Miss Quick.
She has provided me with some information that she's got in contact regarding getting a GED.
You've seen it?
She's gotten
What do you
employment.
think? When?
Gainfully employed as of last week in a place in Galveston to get money.
Okay.
Looks like she's talked to a couple of people at Ball High School regarding the GED program.
Okay. Has she enrolled in anything or?
She's not due to the money. She's just started a job just to save up.
So where is she? Come up, Miss Quick. Come up. You know, the MAC has a program where they can help with getting a GED and it's a pretty low cost. What kind of fee did you get? Did they quote you for doing that?
This one was $24 online, but I didn't have a way to pay for it, so I got a job.
Is that per class or how does that work?
No, it's for the whole program.
$24
For the monthly I pay.
to get your GED?
Yes, sir.
$24 a month. And how long is it for?
Lifetime, or I could pay 180 for lifetime,
It's 90 lessons.
90 lessons.
So however long it takes you to do 90.
We have a program with the public defender's office where for $150, you can get your GD and it's a complete cost of the program. So I don't know how much that would be versus this one here. I mean, we'd have to somehow calculate to see how expensive it would be. I would imagine you'd want to do the cheaper one. It's not going to be just $20. It's going to be that's probably going to be a recurring fee that you have to pay. So find out how long it's going to take you to get it. If it's going to be more than $150, I would probably try to do it with the social services that we have here with the public defender's office, because they also help you with the classes as well. So do you have a job now or no?
Yes.
Where are you working?
I work at a convention.
Great. And are you working full-time or part-time?
I work full-time.
That's wonderful. Good job. So why don't we do a 30-day reset? Okay. I want to know more about the classes. You have to get your high school diploma at a minimum,
Yes.
right? So if you are signed up by now and then, continue it that way. If you've not signed up, I'd like to pursue the other way so we can do it with the public defender's office, right? And then just keep us in the loop and make us proud. We want you to get your D. It's really, really important, okay? Okay. All right, so just go ahead, take your seat, and we'll set you off for 30 days. And good job getting the job.
And then I have in your jury box, last name Perez.
Is this a new one?
No, it's a long.
Oh, right. Okay. This one I have a problem. Come up, Ms. Perez. Where have you been for 417 days?
The second time, the first time we listed my case, the second time gave me the lawyer, which I don't know if it was him. And then he told me not to show up.
You have to remain in contact with them. This isn't just you have court one time and you fail to show up. There are consequences. You were charged with a criminal offense.
I didn't know I was supposed to. He said not to show up because I live in Dallas.
But you have to remain in contact with them. And when you don't have contact with them, we issue warrants, man. Pavel, it looks like you had a class and dismiss offer in this case.
Yes, Judge, I'm honoring it.
All you have to do was a driver safety course and they would dismiss this case against you, man. If you are interested in that to get this case dismissed, you can do that, but I'm giving you only a week to get it done. If you fail to do it, I will set your case for trial. You no more offers in this case. Is this what you want to do?
Yes.
Your other option is you can just end up pleading guilty to this case. However, it'll go on your record. It'll be there forever. What do you want to do, man?
I will take the class.
You have a week. If you do not have it done in a week, you get set for trial and I will not take any offers from you, man. You understand? Okay. Anderson.
How you doing, guys?
Hey, bud. Thank you for coming.
No problem. No, Mr. Bob.
Mr. Bob.
Bob, yes, Judge.
Mr. Bob.
Yes, Judge. He was a bum forfeiture judge. The state has extended offer of time served today, but I would like a short reset so I can refamiliarize myself with the case. Because like I said, he's been gone a while, so I need to look over it.
The case is nearly 400 days. I'm okay. I can give you a week if you want it, but in a week, he's got to come back and just be ready to do something, you know?
Okay, so I may have to do it the week after next, because next week I'm swamped with case. So can we do it?
Tell me what day you want.
Maybe 16th or 15th.
I will give you the 16th.
Okay, appreciate it.
That's it.
Okay.
Mr. Bob, come up. Are you here with that person in the red? You came with her?
Yes, sir.
Mr. Bob, your case is nearly 400 days old. It's time for you to make a decision.
Yes, sir.
Mr. Henderson is here now. I'm giving you until the 16th to figure out what you want to do. You must either accept a plea bargain from the state. If not, your case will be set for trial and I will not take any more offers after that day.
Yes, sir.
That is a final plea deadline date. Do you understand, sir?
Yes, sir.
Okay. All right, just go ahead, take a seat. We'll have you sign a receipt. We'll get you out of here, sir.
Thank you, Judge.
Thank you, Mr. Henderson.
Thank you.
You're going.
Good morning, Your Honor.
Um,
I've talked to the, my office about the case and got him straight, and we're gonna stay on the case. And, we probably end up withdrawing off the felony, but we're gonna stay on the misdemeanor case.
Sure.
Yeah, positive. And
What's the last name again?
Johnson, Your Honor. Yeah, Johnson.
That's right, Johnson. Okay.
And also your problem child back there that was making all the noise, got him calmed down. Explained to him, hey man, you're not gonna litigate this case today.
I don't know what's going on with him really.
And he's not totally unreasonable. He's thinking the handcuffs are on too tight. I said, well, if you calm down and talk to them like gentlemen, they'll say, hey, man, they are too tight and release them.
Well, we're gonna hopefully hear and.
I gave my number in case he wants to hire a lawyer. I said, hey, man, you're not gonna litigate this case. Now, you do have a defense, but you need a lawyer. And
we've already someone in.
Yeah, I figured that. I figured it out. And I said, that's what I told him. So I said, man, just calm down. You're not gonna win the fight. That's what I told him. So have a good day, Your Honor.
I guess just get whatever date you want. Doesn't
Okay.
matter to me for Mr. Johnson. And then I'll do the bail order now.
Thank you.
Sure, thank you.
Hold on.
Yes, ma'am. Mr. Castaneda?
Quick, come on up.
Wait. What?
Are you gonna qualify?
Hey, Greg. What's up, buddy? Come on up.
I have a fugitive, Fawcett, F-A-U-C-E-T-E. She had signed the waiver, but now she's saying she wants a bond. So.
What's the last name?
Fawcett, F-A-U-C-E-T-E. I don't know how to pronounce the first name.
I think that sounds right, Fawcett. Great.
So she had waived on 6/28, the reset would have been 7/15. Now she's saying she wants a bond. She claims it's a robbery out of Florida.
Val.
Well, Amy's here. Amy.
I apologize, Judge, just a minute.
Sure thing. Take your time.
You want to run another court, come back while?
I don't know. I mean, I don't know how.
I don't know how long. You need her brought out, or do you want to hear it first?
No, we need to bring her out so she can hear and so we can. Ms. Garza, on Johnson,
Council for recess?
we did the bond reduction. Was he in a CPS, was the complaining witness in a CPS office, or where was she when he came in and threatened her? And then did he threaten to kill her too? Is that what happened?
No, he just said I didn't get you.
Okay. But where were they again?
Mr. Bob.
We'll sign and Harris County Assessor's Office.
Waiting on day. I'm just gonna reset something in A, Judge. I'll be right back.
Sure thing.
Or actually, Your Honor, it says the DMV. It says both the Harris County Assessor's Office at 5300 Griggs Road, and then also says the complainant was sitting in the DMV office. So maybe they share an office. Let me look it up.
That's right. So that's also, that's a justice of the peace, and it also, it's a simultaneous, is it?
Oh.
Bernie's there, I think.
Justice of the Peace and the assessor.
Yeah.
Council for recess? Judge?
Mr. Hayes' drug test was negative, and since his last,
For Johnson
report
and
back
Ashton.
to IOP, he has registered for IOP as well. He says he has 3 classes, I just don't have the update on how many classes he has left. His
Okay.
attorney lives.
The attorney should be back though, and then we can figure out as soon as they're ready. What do you do for a living, sir?
Right now, it's better business. It's like door to door, picking up trash.
Do you work for a company by yourself? Who do you work for?
It's called valid living.
How much money do you make a month? I don't believe that. In an entire month? Come on.
Yes, sir. It's every 2 weeks we get paid every 2 weeks. It's like $300.
Where do you live?
$1 an hour.
Where do you, okay, if you're making $14 an hour, then that means you're barely working. How much hours are you putting in a week?
It's like from 8 to 11 every night. Monday through Sunday through Thursday.
So you work 3 hours a day? Why?
I mean, that's the only thing that I have right at the moment. I'm working on finding another job. I had another job, but I was working at Republic, but they something happened with the budget and they cut everybody.
So where do you live now?
With my mom right now.
Car?
Yes, sir.
What kind of car you got?
A Buick LaCrosse. A Buick LaCrosse.
And do you pay rent?
Not at the moment. I mean, I help out. I give her what I can give her, but not much.
Deputy, do you mind giving me an application, please? I'm gonna give you an application. I need to know everything about you and I'll take a look at it. All right.
Yes.
Okay, Robles, come on up.
I need to know, I need a drug test.
Negative.
For what? Everything. He knows we got no alcohol, scram, GPS, curfew. Don't muck it up.
Where did I go?
No.
Graham?
I haven't done the revision. She said wait till we get
Okay, so,
there.
right, so on one ankle, we get a scram ankle monitor, so he's not, so we know he's not drinking. On the other one, a GPS monitor and a curfew, 9 PM to 6 AM. No dope, no weapons, no driving, and no knuckleheadedness. Do you understand?
And you paid it.
Yeah.
Judge, we did have another CHA that was here earlier.
Okay, give me. Let me see. Mr. Horn.
Yes, Your Honor.
Okay. Shatoria, you ready? You back?
Yes.
Okay. Come up, sir. I'm glad that the test was negative. That's great. They've told me now that you've enrolled into the intensive outpatient treatment, correct?
Yes, sir.
How often are you going?
3 times a week. I have 4 classes.
Great. When, so when did you sign up for that?
May 28th or 20, it was May.
Yeah, that, I believe it was late last month, Your Honor.
Say that again?
Late last month, Your Honor.
My completion date is July 7th, next month.
Of next month.
The verification I have says May 16th. May 16th is the
Okay.
verification.
So you said it ends July 7th?
Yes, sir.
That's in a
I
week.
have I've done 14. I have 3 this week, and then Monday will be the last one.
Wonderful. Okay, so let's set it then for 7th is a Sunday. You go,
At the 8th, I'm sorry. Well, we go on Sundays though.
why don't we do this? Why don't we set this for the 10th, just to make sure that we get all the paperwork? If you are able to make all those classes and you don't miss, right? And they're ready to file the dismissal, I'll waive your appearance, so you don't have to come here. If you do not make those classes, you got to be here though, and it's not going to go well. But just look, you're at the tail end. All you do is make those 4 classes, this thing gets dismissed. So you're nearly there, okay? So why don't we set up at the 10th just to make sure that he gets everything done, and then, all right, good luck.
That sounds good.
You're doing good. Okay, Mr. Horn, we'll set it for the 10th, and I'm going to waive his appearance, assuming he does it, okay?
Absolutely, Your Honor, and I'll check in early next week.
Yeah.
Okay.
Yeah, all he has is
Thank
4
you very
classes.
much.
Okay, thanks, Mr. Horn.
Okay, thank you, Judge.
Ready?
Oh, yeah, Faye's here. We need her phone. You want to?
Wait, do I know you? Huh? Who are you?
Should be out now that Dave's here.
Dave, we're getting it.
This is the biggest one.
All of it.
That's right. Oh, we sure are. Becoming the country that was toppled.
Yep.
Is the correct person, right?
Carl, what's up?
The other stuff I won't argue, just that one. Everything else is juvenile history. It's serious juvenile history.
That's fine.
Just the ad.
I told her just keep it away if she wants. So. Or her dice to roll.
State is this Florida absent. That makes the most sense.
She on probation for that out of it? What's the robbery?
No, that one is, it's a bench warrant, but I'm not sure. It don't show that it's deferred or probation.
Okay, this is judge. He's gonna hear from the prosecutor your criminal history, and if he thinks you're a candidate, someone that should get a bond.
Good morning, Ms. Fawcett. How's jail?
Not good.
Great. That's good news. Because if it was fun, then we'd have a problem. You were wanted here, or we have you in jail here because you're wanted for some crime out of state. I have no idea why. The first thing I'm going to tell you is that you're a fugitive, so you are an inherent flight risk. I don't know anything about you. All I know is that you want a bond. My primary concern are two things. Number one, and most importantly, is if we let you out, is the public safe? And number two, if we let you out, are you going to go back? Hold on.
Sorry.
Speak on money.
You know, everyone here tells me it's little bunnies jumping in the woods, that it's all hunky-dory, little, but on paper is how we get to know you. I know that you're going to tell me stuff, but how would I know any different? I've never met you. I don't know you at all. That's why I look on paper to really see how and what kind of person you are. All I know is that you're wanted out of Florida for robbery with a weapon. Mr. Kim.
Your Honor, state would be opposed to a bond. She was recently convicted of assault public servant, and I don't know how the enhancement worked in their jurisdiction, but that would put her 5 to life here. And so because it has a potential for a life sentence, is that we'd be opposed to a bond because of the.
I can't give a bond on a potential life sentence.
So the issue that I had with that, and I didn't have enough time to check the Florida statutes, is I don't know what they're to be forthcoming, is I don't know how their enhancements work in their jurisdiction, but I know from Texas because of the way it's charged that I would be opposed. And so I can't equivocate it because I don't know the Florida.
You want to roll to tomorrow to see?
It'll take me a couple minutes, but I can look it up now.
I mean,
but I would still be unopposed regardless, obviously.
I want to know if I'm not allowed to at the outset, because I don't want to give her a bond if I do, and then it's a potential, anything that has a potential life sentence, I cannot give a bond to. And I don't know, I obviously don't know about Florida law, but if you have prior history and they enhance whatever case you may have, it may enhance you to a potential life sentence. I mean, that's the problem with when you pick up cases. You got to be careful. The more things you pick up, it doesn't do you any good.
If I could just have maybe 5-10 minutes.
Take your time. Well, I mean, if you want to, we can also roll to tomorrow. Greg, can you be here tomorrow?
Well, if it's,
it won't take me that long.
if the court's okay, I'd like to address it today.
Sure.
I mean, I'm here tomorrow, but I'm sure she would want to address it today.
I know.
I can run a court 6 and come right back. I got a case in there, so it's no, I'm not going anywhere, is what I'm telling you.
Okay, why don't you go to court 6 and then come back?
Okay.
And then, do you have something with Carl too, Mr. Kim? In the room? Okay.
Judge.
Hi, Carl.
Want to give him the cause number?
No, I got it. Risk car, right?
Yeah, risk car.
All right. So the thing that I was looking at, he's wanted for intent to distribute POM, but when I ran the NCSC, it showed that it was a deferred, but they also said bench warrant. Oh wait, no, hold on. This one they didn't get back to me. I was trying to figure out if it was a deferred because that would be a pre-sent waiver and then he wouldn't be able to get a bond, but they confirmed that it was a true bench warrant because the NCSC was inconsistent with what the fugitive packet was. That's why I need to verify it, but.
Is it on docket today or no?
It is, it's on document.
What's the last name?
Rizcar, R-I-Z-C-A-R.
This is what I saw, which is what caused my pause. It said deferred, and so I was looking for a present waiver. Yeah, because if it wasn't, I'd have a lot easier time arguing.
I believe it's still open.
Yeah, it's a true bench warrant.
Yeah.
But in light of that, I wouldn't be opposed to a bond. I'd be very opposed to a low bond. He's had multiple charges over the last 6 years in different jurisdictions. He had this one coming out in 2020. The bench warrant came out in 2022, but during that time, he's been charged here with, well, then 2 open cases, but 1 still open case for another possession of controlled substance charge, a prior DWI that was dismissed at roughly the same time the bench warrant came out. He had a prior firearm charge and another PCS charge back in 20.
Did you represent him in all those cases?
I did, and they were all
Just
dismissed.
because he has a good lawyer, you know, I mean, it's like.
I did see a trend, Judge. But that said, due to the frequency.
Always dapper.
I know, but due to the frequency of the charges, is that
And you-
feel also a low bond, but.
Can I bring him out?
He's not here, Your Honor. So he was put on the Rick court docket today as well. So he's over at 49 San Jacinto in custody. I don't know why I guess they put both of them on the docket today. So he's got a new less than a gram case or 1 to 4 grams case out of the 208.
Do they do Rick cases on 1 to 4? I thought it was less than a grand.
It may be less. Is it?
I mean, I think it's supposed to be under 1, but I know they can make certain exceptions for certain types. I don't want to.
They have, Judge.
Yeah.
I've seen 4,200.
I just don't know what the category is for exceptions.
That's one car, 4,200 is the range. I've seen those.
And it's Adderall, just for the court's information.
Why don't we roll it to tomorrow and then I'll give you one, just see if you guys can agree to one.
And the biggest concern other than the repeated history, which clearly he did a great job, is the fact that this warrant's been open for 2 years and he didn't do anything about it.
And I have some information for the court on that. He has a lawyer out in Georgia, or had a lawyer. There was a change of address on his part. They don't give you a new court date when you leave court like we do. They mail you.
Carl, I don't care.
Okay.
As long as you're okay with the day.
Can we agree to one today? And then if we agree to
Let me
one,
get a little, if it's gonna get rolled tomorrow, I'm gonna probably want a little bit more information from the Rick court. Like I said, I'm not gonna oppose to a bond, I'm gonna be opposed to a low bond, so let me try to figure out the number once I get a little bit more information, since it's gonna get rolled over to tomorrow.
Tell me what you think and then.
I can email you if you'd like, and then before court, so you're not sandbag approaching.
well, okay.
Yeah, because I don't know anything that went on before it got transferred, because,
Nothing went on. It's in the paper.
in terms of the new one, I thought you were talking about the old.
No.
Oh, okay.
Why he's in 49 San Jacinto is because when he was arrested on this one,
Yeah.
they also started him with one enforcement.
I'm also.
So I don't know, we can really figure it out. It's not gonna be.
Well, also, I'll probably ask the office support.
Has he calmed down yet?
Yeah, because they didn't include it in the video, like, they only put the bench one, so
Mr. Goring said he calmed him down for you.
I don't know how much, I don't.
Oh.
Okay, all right. Let me do a little digging, but I'll email you before court so that you're not, Any judgment? Oh,
So I'm showing a 30-year sentence, armed robbery. There's armed robbery with a weapon.
She got 30 years on a
Robbery
robbery.
Up to 30. Armed robbery with a deadly weapon is a 5. Home invasion robbery with a weapon is 30 years with deadly weapons.
but with an enhanced, but.
I don't know how enhancements work.
Yeah.
Mendoza?
Thank you, sir.
That's even more confusing. That's hilarious.
Victoria.
I don't know anything like that.
So you can download.
Mr. D.
Please, Judge.
Okay.
Mr. John Castaneda. Castaneda.
Are we doing time served?
Yes, sir.
Mr. D? What's a probation? Mr. D, it's a probation, huh?
Yes, sir. Yes, sir. Put the water down there.
Is it reduced to a first?
I don't think it's.
Increase size.
Do we know, does he have a prior
He
DWI?
hasn't, no, sir, he doesn't have a prior, he does have a current felony for which they are going to dismiss upon completion of this case.
Got it. Okay. I see that he's charged with the possession upstairs. That's
Same transaction.
anytime you can avoid a felony conviction, you're really winning. But you have to understand that they're not going to do this over and over and over. And if you don't get it, At some point, they're going to throw the book at you. For as it stands now, this DWI will go on your record. It's going to be there forever. And like you heard me probably say earlier, with your history, you have a prior possession of a controlled substance, prior possession of marijuana, now a DWI and a felony possession of a controlled substance. Even though that felony now is going to be dismissed, an officer is still going to see it. And they're still definitely going to see the DWI. So what I'm telling you is that I guarantee you, wherever you go, whatever you drive, the next time you get pulled over, they're going to harass the hell out of you. It don't matter where you're going. It doesn't matter what time of day it is, who you're with. They're going to search you. They're going to give you a hard time. So don't give them the pleasure. Do you understand?
Yes, sir.
The fact that you have even the smallest, faintest odor of alcohol on your breath, they're going to take you in and charge you with a second offense. The fact that you may have anything in your car, you're going to go to jail. From now on, for $20, one click, $15, take you everywhere you want to go. Don't matter where you want to go. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged for executing open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. You are entering into a contract with me now, stating that of all these conditions, you can successfully complete them. If you don't, there are dire consequences, and the consequence is that I will issue a warrant. I'm going to put you in jail. The only thing that we're going to talk about is if you violated this probation. If you do, you are facing 180 days in jail. Do you understand?
Yes, sir.
If you test positive, if you don't do your community service, if you don't do your classes, if you don't show up, all these will be cause for me to revoke your probation and put you in jail up to 180 days. And I'm going to tell you now, I have no problems doing it. I don't care if you get pissed off at me, you get your feelings hurt. I will do everything in my power to protect the public. I don't care who's in front of me. You understand, sir?
Yes, sir.
The conditions are, it's 180 days in jail to be probated for 15 months. You will do a DWI education class. This is how you keep your license. The fact that you do this DWI education class, you get to keep your license. So I'm not going to suspend it now. However, you must obtain a guardian interlock prior. Do you have one now? An interlock.
No, I don't have a vehicle.
How are you getting to point A to point B?
Friends and family.
Do not drive. You will be signing an affidavit with me today for this probation, promising us that you're not going to drive. And I'm telling you, Mr. Castaneda, now, there's nothing that makes me more upset than when someone drives without a license. I literally will, horns will pop out of my head if you get into a car and drive. You will do 2 victim impact panels. You will also do what's called a TRAS. This is an evaluation to see what other conditions you may need. If they assess further conditions, you must complete those conditions as well. Substance abuse treatment. No breath test refusal. If you were pulled over, if you're not wise enough and you get into a car and drive and you get pulled over and an officer asks you to submit a breath sample, you must do it. If you don't, you're in violation. But obviously you'd be in violation by driving anyways. No drugs, alcohol, guardian interlock. Was there an accident in this case?
No guardian interlock at this time, Judge, you said.
I know, it is as part of the probation.
Yes, sir. Yes.
He will, Castaneda, was there an accident? If you do not have a car, no accident. Okay, great. If you do not have a car, you must have a handheld portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. How do you plead to the offense of driving while intoxicated, Mr. Castaneda?
Guilty, Your Honor.
I will find you guilty. I will sentence you to the above agreement. I will not suspend your license. Be careful though. because I'm telling you, this is gonna stay with you for the rest of your life. Do you understand? I would never, even if you've had one beer, one glass of wine, don't get into a car. Because if you get pulled over, you're hosed. Good luck, sir.
Thank you.
Please see the clerk.
Yes, ma'am.
Judge, can I call up a THX?
Yeah. Yeah.
Ferguson, come on up. Page 9, THX.
Did she just get here?
No, she's been here.
Okay.
Just kind of.
All right. Good morning, Ms. Ferguson. Do you not have a lawyer? Do you want an appointed lawyer? Okay. I don't know how she didn't get a lawyer in the first place with this, we always give lawyers with these. Let me see if they have an application on file. It's Ferguson, right? We're talking about the right person? Devin Ferguson? Okay. I don't have one on file, so. Okay. I'm happy to appoint your lawyer today, ma'am, but I have to have you fill out an application, okay? Deputy will give you an application, and then I'll have you go to Victoria, sign a reset, and then we'll just have you take a seat in the jury box while you fill it out, and then I'll have you talk to someone.
From Ramon Justice.
Okay.
So yeah, he's here today. Just to remind you, he did have an unauthorized absence to correctional facility. He pled 200 days to in felonies, kind of day one before we could address it. That time on that set, so it'd be like 70-ish days. That time's up this week. We do have your probation on our trespass case.
I'm sending him back.
Okay.
Yeah, we're gonna keep doing this until he takes it. And then every time he takes off, the same thing's gonna happen. So every time, and I'll explain that to him.
Yeah, I
but
understand. You have judged before.
When does the time run?
He tells me Thursday, but I need to do the math myself. But sometime this week, Judge. If it makes sense.
You wanna set it for Friday?
Sure.
Okay. Can well, I'm gonna amend his conditions to put him back into DDRP. And I'm gonna keep doing it.
Yeah, of course. We'll do that. This is probation.
You mind bringing out Ramon Justice, please?
Sure.
Thanks.
No, it's code trespass and so probation. And as it's a probation. That's her. Yeah, code trespass.
See now in this case, there's like a motion to revoke probation. That's all I'm doing now.
Good morning, Mr. Justice. How's jail? As soon as you're done with your sentence on the felony case, which you say it's on Thursday, I don't know, I'm going to check for you, But we will be doing the same thing where we will be amending the conditions to put you back into the dual diagnosis residential program. I told you that we are going to keep doing this until it takes. I know you don't like it. I know you're upset. At some point, it's going to take. And at some point, you're faithfully going to work the program. Mr. Justice, every time you jump the fence, this same thing is going to happen. Do you understand?
I understand clearly.
Good. I'm glad you do.
Just tired, that's all.
It's okay. Understand, as soon as you're done, back into DDRP you go. Do not jump the fence. Make the program work. Okay. All right.
Right.
Yeah.
Thank you, Judge.
So I'll amend it as soon as Shatoria. Back to DDRP.
Okay, are we waiving all his fees? Okay, just making sure.
It's on today. It's on.
Judge, you have a very important call. 4-8. 5-3.
Because I don't want to let him out. Let's see. Hey,
5, 7.
is there a bed? Is there a bed ready for him or no?
It'll be about 2 weeks before we get it.
Okay, so can we go ahead and amend the conditions now so that it's ready to go?
I'll put them, amend them and have them on the wait list.
Okay, and then can you do me a favor? I'd like to know when the wait list ends because I want to admonish him one more time. The day before he goes to DDRP, I want to admonish him again to see if it sticks. So, so Victoria, let's wait to see what day that is. Well, no, just wait. Because she's gonna be able to see when the bed opens up and then we'll put the day before the bed opens up. I'm sorry if it's a, well, I don't,
So many conditions.
so Miss Garza, do you know Patty well?
Yes, sir.
How well do you know her?
We started the same section together as spring starts, so naturally our section is pretty close and she immediately.
Is she like the mom, really?
Yeah.
She's so sweet, isn't she?
Yeah, she
Just-
really is the best.
She's like that, and I've known her for a long time, and she's always been so, just like that, just such a sweetheart. And it's about time that she finally went to law school. So I'm glad that she did that. It's great. And yeah,
She's studying for the bar right now, so she's gonna take it early, but still walk with our section. And
so how come she didn't get a job with the DA's office? Did she not want to?
I just know that right now, this summer, she's studying for the bar because she's going to take it in July.
Trinidad.
Good morning, Your Honors. Good morning.
Whenever you're ready, let me know.
Hey, Your Honor, we got appointed to Hightower. I asked the bailiff earlier. If we just got one appointed. I don't know if you want somebody there. I see Mr. Dixon's still available.
Judge, he's wanting me to appoint somebody else. I'm doing it.
Okay, we'll do that. Not a problem, Trinidad.
Thank you. I appreciate it, guys.
Sure.
Hey,
Because it's enhanced?
Yeah, the
Or is it a deadly weapon?
Deadly weapon.
Oh, so it's not robbery with a weapon, it's robbery with a deadly.
Yeah, he just checked it's a firearm. So.
Bring her out.
Yes, Judge.
Do you mind bringing out, what was her name?
So robbery with a firearm was 30 years, but no, robbery with a weapon is 30 years in Florida.
This one's
With
false.
a deadly weapon makes it life, right?
Young
And the
lady.
enhancement doesn't even matter.
Yeah, so because I asked if the APS would enhance it, and he was like, I didn't even get to that. I looked in the report, I'm guessing he found it was firearm, so yeah, the firearm kicks it up. First
Okay.
degree. Which I had to go through 4 different agencies to get that answer. I was on the phone with so many people and I had such a simple question.
Well, they have that weird points code, whatever it is. It's like some weird points. It's like a federal points.
Yeah, there's 2 people from their county's office and then someone else at their DA's or state's attorney's office and then the actual person assigned, so.
Well, I'm gonna tell her she needs to keep her waiver in place because her reset date was July 15th, so she can do what she wants. with it.
Yeah. Do you need my phone?
I assume they're gonna come get her. so.
Certainly are now.
She wanted to turn bond.
It's David Fleischer.
Careful what you wish for.
Hey, Uskonga picked up a new case.
I wasn't even gonna come to court, but then she's like, oh, 2 people want to buy.
No, well, are you going to be representing him on the new case? Okay, so they're on for Monday. He's got to be here at that time. And then I'll see with the state if they're gonna keep him on or not. Okay? Yeah. Yeah, and then so I'm putting all cases on for Monday, okay? Just please let him know he's got to be here. Okay, thanks, man.
Over the other county?
Yeah, let me just write this down for you.
She claims it's robbery with a weapon, not a.
Okay, that's from the state's attorney I spoke with. I mean, I can call him back again, but maybe just.
Yeah,
my
can
phone.
you please, because it's just a
Well,
weapon. It's not-
I don't
it's
have any
not
way of.
deadly.
I don't have access to it, Your Honor. So the state is claiming it's a firearm. My client is claiming that it's a weapon, robbery with a weapon. So the difference is 30 or life, depending on what the actual charge was.
Right, so bottom line, I'm not gonna set you a bond now as it is, because I just don't know. I mean, if it's a crime that carries a term of life, I just can't give you one anyways, as even if I wanted to, I couldn't give you a bond. So at this point, why don't we just set it? She already has a waiver in place, right?
There's a waiver in place. The
So that
pickup
you're not
is
losing time.
Pickup was scheduled for July 15th.
Right now, like you said, it's scheduled for July 15th. I would say at the minimum, keep your waiver for now, because if you pull this waiver off, you'll lose all that time that you've done in custody now. So in the interim, they can take a look to see whether it is or not. But regardless, I'm gonna have a hard time giving you a bond as it is. You're a dangerous person. I know you say no, but paper says different. So even if it's not a deadly weapon, it's still a robbery case. A weapon was used and you're on, and what else did she have?
So she had a prior conviction. She was released from parole in 2020, but that was for insult to public servant. She had 4 years TDCJ.
Yeah, at some point you gotta. Actions have consequences, Miss Fawcett. You cannot continue to pick up cases and something. So I guess let's just, you tell me guys what you want to do.
That has nothing to do with it. It doesn't matter. You have convictions. The judge explained that to you. I can't force the judge to give you a bond.
I'm not like
You're a-
telling you to force him.
Well, you have a
to,
fugitive bond.
But you didn't even look into the paperwork or anything.
Because I was just appointed today and I don't have access to Florida, ma'am. I will reset. Can we reset it to Friday, Ron?
Yeah.
Okay.
Well, let's do Thursday or Monday. Just
Thursday's
because,
the 4th, so we can't.
right.
Sounds like Wednesday or Monday.
And then, yeah.
I can get a copy of the offense report. Obviously, it's gonna take time because they're gonna have to make sure, I am who I say I am versus some rando asking, so it's gonna.
You think Wednesday enough time?
No, Wednesday will be enough.
Okay, let's set it for Wednesday.
The state could share her Florida record for me, because my client seems to think I can just produce Florida records, which I obviously can't to look at.
Yeah, I can
Get it
use a
free.
copy, but yeah, I can write it down manually because I can't. Yeah, I
Okay.
can do that.
All right, good luck, Miss Fawcett.
Thank you.
I'll see you Wednesday.
Friday or Monday?
Wednesday.
Wednesday.
Oh, yes.
DeLeon is the first one, page 28. Chambers County said they can pick up tomorrow. Did you see who broke his pen? Who broke his pen? I don't know. I tried to put glue on it.
I don't know why De Leon's not showing up here. It's
Oh,
weird.
because I did,
Oh, you did the
Dr.
thing already?
Reset.
Okay.
Mhm.
Oh, and then we said,
Yeah, but they didn't enter it, so I was like, okay, that's why you came up today.
Yes, I'm okay with that.
Yes, okay.
Tomorrow's okay.
And then page 29, view, Liberty County burglary of a half felony, no bond was set.
But have they said when they can come or no?
No, nothing, no updates, nothing. On a clerk salary, ma'am. Yeah. So pretty too. Hot glue, what if we just hot glue?
Mitchell.
Asked me to do the field sobriety. And I told him I couldn't do the walk and turn, so yeah.
B misdemeanor DUI.
Can you hear me okay?
I can hear you, Judge.
Thank you.
Yeah.
Very good. Let's go on the record then. We are on the record in the 13th Judicial District, the District Court of Butler County, Kansas. This is our Monday, July 1st, 2021 misdemeanor control docket. And Mr. Watts, let's take up your case.
Good morning, Your Honor.
Good morning.
I have here in the office Harley Guy.
We are on the record in 2024 TR 805. Please announce appearances.
Jared Regier on behalf of the state, Your Honor.
Your Honor, James Watts on behalf of the defendant who appears in person.
And how does your client wish to proceed today, Mr. Watts?
Your Honor, my client is charged with a first-time DUI as well as leaving the scene. And I've not had a chance to speak with Mr. Regier this morning, but my client wants to resolve this matter as quickly as he can. He does have, well, if the state is willing to dismiss count 2 of the information, which is leaving the scene, my client's prepared to enter a guilty plea this morning to count 1, which is a B misdemeanor DUI.
And Mr. Regier, are you able to address that?
One moment, Your Honor.
And if we need a breakout room among attorneys, if that would help resolve this in an expeditious manner, I'd certainly give that to you, even though we do have a very full docket.
Your Honor, after further review of the case file, the state is prepared to proceed in that fashion.
Very well. Your client wishes to plead in what manner, Mr. Watts?
He'd plead guilty, Your Honor, to count 1, which is first time B misdemeanor DUI.
Thank you. And Mr. Guy, is this what you want to do today? Plead guilty to count 1 in exchange for dismissal of count 2?
Yes, Your Honor.
Is anyone making you enter this plea of guilty today by any kind of threat or promise?
No, ma'am.
You're pleading guilty because you believe you in fact were driving with a BAC of 0.267 in Butler County on January 27 of 2024?
Yes, ma'am.
And where were you doing this driving?
On Boyer Road, going home.
Boyer Road there in El Dorado?
Yes,
Okay. And do you understand that if we proceed with this plea, you will be found guilty, you'll be giving up your right to a trial, and you'll not be able to appeal your conviction?
yes, ma'am.
And knowing that, you still wish to proceed with this plea,
Yes, ma'am.
right? And so you said you were on Boyer Road in El Dorado, which gives us jurisdiction. You've said it was January 27 of 2024. Had you been drinking prior to your contact with law enforcement?
Yes, ma'am.
And what had you been drinking?
Just beer.
And do you remember how much beer you'd been drinking?
No, ma'am.
But there was something about your driving that caused you to pull, the officer to pull you over, or what happened in your own words?
A deer ran out in front of me and I swerved to miss him and I got stuck in the field.
Okay, and then did an officer come out?
Yes,
What happened after that that made you end up with a DUI?
they asked me to do the field sobriety and I told him I couldn't do the walk and turn. So he asked me if I'd take a blow machine and I said yes.
I bet there was no deer.
And ultimately you blew a .267.
Yes, ma'am.
All right. Well, I will accept the plea and find the defendant guilty of DUI. Mr. Watts, do we have an alcohol and drug evaluation available?
We do not as of yet. I've already spoke with my client about the necessity for getting that prior to sentencing. And if we can set this for sentencing, Your Honor, he will be getting on that immediately.
Very well. Jen, when do we have a sentencing available? 6 to 8 weeks, Mr. Watts?
Yes, ma'am.
Okay.
You want it still on the Monday misdemeanor?
I would think, wouldn't you want that, Mr. Watts, on a Monday? Okay.
Yes, ma'am. Monday morning is fine.
August 26th.
Yes, ma'am.
August 26th, 9 a.m. That works with both state and defense?
No objection to the August 26th date, Your Honor.
Very well. Then, Mr. Guy, I'm going to continue the bond that you're already on under the same conditions. Don't be drinking. And I'm going to add that you reappear August 26th at 9 a.m. And hopefully that alcohol and drug evaluation will be to your attorney before then. so that he can disseminate it to court and counsel.
Yes, ma'am.
Anything further, Mr. Watts, that we need to take up from the defense?
No, ma'am, thank you.
You're welcome. Mr. Regier, anything further?
Your Honor, although does not appear to be specifically mentioned on the appearance bond, my notes from the first appearance hearing this matter would appear to indicate that Judge Crum specifically ordered no drugs or alcohol as a condition of the bond. Based off my notes, are those the continuing orders of the court as well?
Those are, and when I said no drinking, of course, I meant alcohol, and don't take any illegal drugs, Mr. Guy.
Yes, ma'am.
All right, thank you. Thank you, Mr. Regier.
Thank you,
Nothing
Judge.
further. We'll be in recess on Guy. Mr. Guy is excused. Mr. Watts, if you have no other cases, you're excused.
I have nothing else. Thank you, Your Honor.
Thank you. And Mr. Andrews, you are here for whom?
Your Honor, I have 3 cases on this morning's docket.
Have you any that are set for warrants to show cause?
No, I don't.
Do you have any that are in custody?
One who is in custody, at least one, I should say. I don't believe Tanner Parscall is in custody, but Amanda Stanley is in custody.
Have you had a chance to speak to her, or do you need to?
I've spoken with her, but I was hoping to speak with the prosecutor about working out a plea on this and see if we can get that resolved.
All right. Do we have just one prosecutor with us this morning, Mr. Regier?
Your Honor, I believe my colleague, Mr. Canfield, is also in the Zoom conference. However, for purposes of entering a breakout room with Mr. Andrews on the Amanda Stanley case, I am available for that purpose if the court will indulge me.
I would like to do that. So Mr. Andrews and Mr. Regier will be admitted to a breakout room if you're able to accommodate that, Jan. And does the jail have Miss Stanley available?
Yes, Your Honor, she's here.
All right. We might see, who do you have with you now? Wait a minute, who do you have? Who is that?
This is Mr. Minifield. He is Mr. Patterson's client.
Is Mr. Patterson available?
Your Honor, I believe Mr. Patterson is still in a breakout room, and he and I have not had an opportunity to discuss any of his cases.
All right, well, we'll see if you can do that as soon as possible, at least concerning those that are in the jail. And yeah, are there any other security facilities with us besides Butler County today? And then I see we have some probation officers. Who did I see here? Mr. Bauer, which case are you here for?
Your Honor, I'm here on Casey Mumlaw. I believe she is pro se.
Okay, I did see, that's Casey Mumaw. How do you pronounce your last name, ma'am?
Mumaw.
Mumaw?
Yep.
Okay, and Ms. Mumaw, it does show that you don't have an attorney. Is that correct?
Correct.
Well, let's take up your case. Mr. Canfield will take up case number 2022 TR 3985 on the record in state of Kansas versus Casey Elaine Mumaw, with Devin Canfield appearing for the state. Ms. Mumaw appearing in person and pro se. Also present is her court service officer and supervising probation officer, Tony Bauer. We are set today on a bench warrant concerning motion to show cause why defendant's probation should not be revoked that was filed in April of this year. Now, Ms. Mumaw, why is it you do not have an attorney today? Do you not want an attorney?
Honestly, I don't know how all of it works, so I'm not sure if I shall get one or if I needed one.
Well, let's talk about that. As I said, you're here because a warrant was filed to show cause why your probation should not be revoked. In other words, Mr. Bauer is alleging that you violated your probation. You went on probation for driving while suspended on November 8th of 2023 here in Butler County. You were ordered to pay costs and fees and to report to your probation officer as directed. But Mr. Bauer is saying you have violated your probation by not paying costs and fees and not reporting as directed. So if I find that that is true, I can revoke your probation and I can make you serve the sentence that you were originally given.
Karen, what's your message?
Karen, how are you feeling right now?
What do you want to say? Karen, you have anything to say about where the jury's at?
I think this is them headed back into court from lunch.
Karen, are you still feeling confident?
Absolutely nuts, in my opinion.
Bye. How you have grown. Oh, parents.
Sure. Let me turn this back on. You're right, Al. Mr. Reed, are you still feeling confident?
It's the weekend. Come on. What's the plan for the weekend?
Oh, this must be a replay.
Good call, Al.
I've been doing it long enough.
You
How are you feeling? You got a good weekend?
How are you going to celebrate if she's found not guilty?
I paused Mima and the Moo Moo for you. We'll go back to it live as soon as we figure out what's going on here.
How are you guys feeling after the weekend?
Karen, how will you celebrate if you're found not guilty? Give me some bananas.
You're good about that. I let you yell it. I'm standing beside you.
Yeah, tell me what's else.
I mean, you could try the same thing, like how are they feeling after the weekend? How are they
Ask them
celebrating?
how they think about Karen's supporters.
Did you guys hear about the prisoner that escaped? Yeah, I think this is replays. But hold on. Let me figure out how to share this screen.
Alan, how are you feeling this morning?
Very good,
You think
thanks.
this is gonna be a verdict?
Karen, how will you celebrate if you're found not guilty?
It's showing up.
You know what? I'll let you get in front.
Let's go, Karen! Let's go, Dream Team! We love you, Karen!
Super interesting to watch how Karen Reed responds to everything, right? So at the very beginning, when closing arguments were happening and the jury was just beginning its deliberation, you saw Karen Reed walk in and out of the courthouse with sort of an air of confidence. She was smiling. She was even answering before questions when we shouted at her. Now it's been more than 1 hour.
Why is this not showing up? Okay, I don't know what's going on. So apparently I can't get it to pull up Twitter, but there was a prisoner that escaped in the middle of all this craziness. You can't really see anything, but he escaped from the courthouse and went running through the crowd of the Karen Reed supporters. Yeah, that's interesting. All right, let's go back to this. Mute you.
Which would have been November 8th of 23. You were given 8 months as an underlying sentence with a 12-month reporting probation. So if you didn't complete the 12-month probation successfully, it can be revoked and you can serve the 8 months in jail. You understand that now?
Yes, ma'am.
So that's what's at stake. You could be revoked and you could serve that 8 months in jail. And at the November hearing, you did waive your right to counsel and entered this plea, but you are looking at potential jail time. So do you want an attorney to represent you in the revocation hearing?
That'd probably be the smartest thing because I'm 4 months pregnant, so I don't think 8 months would be good for me.
Well, women do have babies in jails and prisons on a regular basis, but I don't think that's ideal, but it does happen if you put yourself in that position. and your baby in that position, but you're certainly entitled to an attorney because of the potential jail time. And you either can apply for, you can either hire an attorney. If you cannot afford one, you can apply for court appointed. But it looks like we've been extending this for a while now. Looks like you made your bond around April 30th, and then you saw the judge, or you were supposed to see the judge, and then you had that extended to today.
Yeah, I had a warrant. They picked me up on the warrant. Well, I went to Cedric and they transferred me, and I had seen the judge that day in court. Well, before I got out of jail, I think it was you, Webster.
Okay. Well, all right. What's your situation? Are you employed?
Yes, ma'am.
Where do you work?
The Oxford Grand in Wichita, Kansas.
What's the name of the business?
The Oxford Grand.
Officer Grand?
No, the Oxford, OXFOR.
Oh, Oxford Grand. And what kind of business is Oxford Grand?
It's an assisted living memory care.
Okay, so you work with the elderly as they're getting dementia and things like that?
Yes, ma'am.
Okay. How long have you been doing that?
I passed the medication. I've been doing that for about 2 years and taking care of them for about 4.
So are you a certified med aide?
Yes, ma'am.
And how much per month do you make doing that?
18.
18.
Or you said monthly, my bad. 18 hourly, monthly, I would say roughly about 2,400, 2,500.
Okay, and do you pay rent or mortgage?
Yes, ma'am.
How much do you pay for rent or mortgage?
1,000 for rent, and then electric, gas, and water.
How much do you pay for that?
Gas is normally 50 to 80 bucks. My electric is normally 100 to 150, and then my water just kind of fluctuates just depending on how much I use it. So I'd say between 50 to 120.
Okay, and then you have a child on the way. Are you supporting any children right now?
No, ma'am.
Okay, are you married?
No.
Are you getting prenatal care?
Yes, ma'am.
And are you having to spend any money on that?
No, I have insurance.
Okay. Do you have any other expenses?
Just a car payment.
And how much is that?
$230 every 2 weeks.
It's about $460 a month. And you have food, clothing, and such. All right, I'm going to appoint Attorney Darren Patterson. Have you had Mr. Patterson before?
I don't think so. I don't think I've had an attorney before.
Do you have a way to write down his phone number?
Yeah.
And I would advise everyone participating today to make sure your pencil and paper are in your hand when I call your name.
Yes, ma'am.
Thank you.
Okay, and you said his phone number is what?
It is 316-322-7700.
Okay, and you said 7700, correct?
I did, and it's Darren Patterson, Darren Patterson.
Okay, thank you.
You're welcome. Now, I want to set this hearing as soon as we can, since we've been postponing it since April. And Jen, what do you have coming up within 30 days? Hopefully no longer than that.
Our next available is going to be August 26th.
Now, we could put that on a 1:30 docket since it's a show cause. Is that still?
Do you want a bench trial date?
Probably, I would think. Mr. Bauer, are you available on Wednesdays at 1:30? Or would you rather keep it on this docket?
As long as I have nothing with Judge Lee, That's typically, if I have anything, it'd be with him most generally on a Wednesday. But I don't have a whole lot scheduled with him at this point.
Well, let's go ahead and leave it just for good measure, August 26th at 9 a.m. Ms. Law, you'll need to be back here. I'm going to continue the bonds you made, but I'm going to order that you reappear August 26th at 9 a.m. I'm also ordering that you call Mr. Patterson's office this morning and give them your information.
Okay.
I don't want you and Mr. Patterson to show up here and not have talked. I don't want him to show up and need more information from you. I want you to be ready to go. And also, Mr. Bauer, has she appeared at all since November?
She has messaged me twice on a weekend, and then we scheduled an appointment and she missed that appointment.
Want to see her again between now and August 26th, or try to see her?
Yes, she could actually call me when court is over and we can get her stuff set back up and going, and I can get her another report date.
All right, Ms. Mumad, you better take down his number and call him. Mr. Bauer, what number do you want her to call?
316-452-4781.
Okay, thank you. And would you be you want me to call when I exit the court, or you want me to give it a little bit?
As soon as we're done here, I'm finished. So
Okay.
anytime this morning before noon.
Okay, all right, thank you.
Well, I'm ordering that you call him as soon as we're through here, so.
Yes, ma'am.
Covered everything for now. Mr. Canfield, anything further from the state?
No, Your Honor.
All right, then we'll be in recess. Ms. Mumad's excused. Mr. Bauer, you're excused because you said you have no other hearings on the docket.
I do not. Thank you, Your Honor.
Thank you. Are we ready on the jail case yet?
I just put the jail in a breakout room.
With Mr. Patterson?
No, with Mr. Andrews.
Okay. Mr. Kirkman, which case are you here on, sir?
Excuse me, ma'am. Can you hear me?
I did. I kind of lost you on the last name. You said Sheila?
The case number is 24CR022, and the last name, the spelling is CONTRERAS.
All right. We're on the record in 2024 CR 22, State of Kansas versus Shea, DeJaya, Deaqual or Cole Contreras. For the state.
Jared Regier on behalf of the state, Your Honor.
And is Ms. Contreras here? Ms. Contreras apparently is not here, but her bondsman Don Kirkman is. And we are here for motion for judgment on bond. So the defendant apparently bonded out to be here March 6, 2024 on a $3,000 cash or professional surety, or in this case, professional surety, but she did not appear and we haven't seen her since. Mr. Kirkman, what's your response to this motion?
Okay, first off, Your Honor, my paperwork showing that it was a $1,500 bond, and
okay, I do see that she did get it reduced. Oh, I'm sorry. No, the original bond that we're here on was $1,500. When the warrant issued, it was doubled to $3,000. So you're right. We're here for motion for judgment on $1,500. Go ahead, sir.
I have not caught him yet. I've been busy chasing others, and if there's any way possible, I would appreciate an extension on it.
Okay. Driving while habitual, interference with law enforcement officer. Are the charges still pending? Where do we think she lives according to what she put on her bond? What state?
In Wichita on 2526 East Conquest in Wichita.
You had any contact with her since she made the bond in March?
No, I haven't at all. I am in Wichita right now, though, so I'm going to go by there.
Well, okay, what's the state's position on the request for an extension to give him a little more time to try to find Ms. Contreras?
Your Honor, it would appear that a motion for judgment on bond was filed with the court some time ago, back on April 19th, with today's hearing date and time attached. It would appear that the bondsman does appear today. At this point, the state is prepared to proceed on the motion for judgment on bond, but if the court determines that an alternative matter forward is appropriate, then I will respectfully be reserving all rights at the next hearing if that is indeed the order of the court.
Well, we can do it one of several ways, as everyone knows. The court can order judgment, but withhold enforcement, or we can just continue the hearing, as Mr. Kirkman's asking. So, since this is your first request for continuance, Mr. Kirkman, I will go ahead and grant the continuance. What are we having, about 60 days, Jen, to take this motion up again?
Give me just a second.
Okay.
Looks like September 9th.
All right. Is there any objection to September? You said September 9?
September 9th.
9 at 9?
That's right.
Okay. All right, Mr. Kirkman, that'll give you till September 9th at 9 a.m. to find her, or I will proceed on the motion at that time. Anything?
Understandable.
I'm sorry, Mr.
Another one, but I believe that one's taken care of. I said I also had another one, but I believe it's been taken care of.
All right, what was it for the record?
Desiree, it was a traffic case 23 TR 3557, Desiree West.
Jen, do you still show her on the record?
I'm looking.
Did you say Desrick West?
DEZRICK.
That has been canceled.
I saw that is still on the docket. 23 TR 3557, you said, Mr. Kirkman?
Yes, Your Honor.
That has been canceled.
And Your Honor,
Yes, Mr. Regier?
for the court's application, if the court is prepared to go on the record, I believe I am in a position to address that summarily.
I am, although I do show Mr. Patterson's record, but it sounds like you said summarily, so do you want me to go ahead?
Well, Your Honor, on further review, it would appear that the court had appointed Mr. Patterson to this case. So perhaps it would be more appropriate to wait until Mr. Patterson rejoins the Zoom conference.
Any way we can get Mr. Patterson on here for some of these?
I do show that that was canceled due to the defendant appearing before you on 4/24.
All right. And is that what you're showing, is that it's been canceled, Mr. Regier?
Your Honor, based off my notes, it would appear that the court did continue it to today's date and time and specifically appointed Mr. Patterson to this case. I do not have notes to indicate that today's hearing was canceled.
My apologies, Jared, you're correct.
Well, but you are too, because the point we're addressing right now is whether Mr. Kirkman needs to stick around or not. And it sounds like we've already addressed the motion. It's off the table, but we still need to wait for Mr. Patterson, his client, later.
That would appear accurate, Your Honor, based off my notes and a prior order in this case. But again, given that Mr. Patterson has been appointed to this case, it would appear more judicially prudent to wait until he is available.
I see him on here, so we're going to take this up.
What case is it, Judge?
It's Mr. West, Desrick West, the very last one on my list.
I did not have that on my list for some reason.
Well, let's call that case. We're on the record in 2023 TR 3557, State of Kansas versus Desrick Antwain West. We have Jared Regier appearing for the state, Darren Patterson appearing for the defendant, but is the defendant here? Well, we may need you, Mr. Kirkman, after all. This is a case that was set for motion for judgment on bond. The bondsman is here, but he has been given notice correctly that that issue was resolved on April 24th of 2024. The motion was withdrawn. The defendant was reinstated on his $1,500 bond with Mr. Kirkman and his company, with the orders that Mr. Patterson be appointed and that the defendant reappear July 1st, 2024 at 9. Now, I'm prepared to tell you, Mr. Kirkman, that you're free to go, and you are, but as a practical matter, your client apparently fails to appear again, so maybe you can find him before we have another motion, because I am going to order judgment. Well, I'm going to order bond forfeiture bench warrant. So you have a little heads up on that in trying to find him. Mr. Patterson, I'm not sure why you haven't received your notice of appearance, but you were appointed to him 2023 TR 3557, first name Dezrick, middle name Antwain, A-N-T.
And Judge, I do see it on the docket I received from the clerk's office, but on that docket, it does not show he has counsel. Has an order of appointment actually been filed?
Well, I'm seeing it on the summary that you have. Let me see. The order appointing was filed 6/26/24.
Okay, I just haven't received it yet then, Judge.
I think that's it, and I don't know why, because I do see that it was signed and filed with the date and time, but somehow it must have lost its way to your hands. So please make a note that he is your client. I'm sure I've ordered him to call you as soon as the appointment was over, as I do that very consistently. All right, so that's the status of Mr. West.
Your Honor?
Yes, Mr. Regier?
Your Honor, if the court is making certain orders regarding the defendant's additional failure to appear, as it would appear today on the record, is the court making any orders about the amount?
I think we'll just, as kind of deja vu, we'll go back to where we were before the bondsman got him here. We'll go back to that 3,000 cash or surety.
Very good, Your Honor.
So that's bad news and good news both, Mr. Kirkman. Good news is you were off the hook, but it was only for a short while. So, all right. Anything else we need to address?
And the money doubles, Your Honor.
It doubles. Yes.
The money goes to 3,000. Do you have an address on him? I have one if you don't.
Okay. If you find him, you bring him in, and somebody else can make the new bond if they want, or however you want to proceed. That's certainly up to you on that bond. But the first bond is ordered forfeited with a bench warrant, a new bond at 3,000. Maybe you'll get him back in here again.
Thank you very much, Your Honor.
You're welcome. Thank you.
Judge,
You have a nice day.
Judge, may I have a breakout room with Devin Canfield?
Yes.
Thank
I
you.
will wait. Are you ready? There was someone in the jail. Did we need to take that person up first?
I need to talk with Devin about that case.
All right. So if we can put, Jen, if we can put Mr. Patterson and Mr. Canfield in a breakout room. Mr. Andrews, are you ready to proceed on someone now?
Yes, Your Honor. Amanda Stanley, who's in the Butler County Detention. Or
Oh,
who's in
is
the
she going?
Oh.
Okay, that'll work then, right?
Yes.
Mr. Patterson?
And we have a plea worked out on Miss Stanley.
Okay, let's take up Miss Stanley then. On the record in 2024 CR 30, State of Kansas versus Amanda Jane Stanley. Please announce appearances.
Jared Regier on behalf of the state, Your Honor.
Joshua Andrews on behalf of the defendant, who is also present.
Mr. Andrews, you said you had some type of announcement?
Yes, Your Honor. The prosecutor is willing to amend the charge to deprivation of property. And Ms. Stanley will enter a plea of guilty to deprivation of property. There would be a joint sentencing recommendation of a $200 fine plus court costs, a 12-month controlling sentence with 12 months reporting probation. A condition of that probation would be no contact with the co-defendant, the victim, or the victim's property.
Any restitution?
I believe it was recovered, so I don't believe there is any restitution.
On the issue of restitution, Your Honor, it is the state's understanding that that is not applicable in this particular matter. In exchange for a plea to criminal deprivation of property, which would appear to be a Class A non-person misdemeanor per statute, the state is prepared to agree to recommend a $200 fine, court costs, while deferring to the court on the issue of attorney fees, a 12-month underlying sentence with 12 months of reporting probation, $6 probation fee with all standard conditions, and the no contact order with the victim or the property.
Is that under the same statute, 215801?
Your Honor, the state's understanding is that the criminal deprivation of property is provided under KSA 215803.
All right, Ms. Stanley, have you heard the attorneys in the court talking?
Yes, I have.
And do you understand the state is amending this from theft, meaning you intended to permanently deprive the owner, to 21-5803 criminal deprivation of property where you took it without permission? That is, criminal deprivation of property is obtaining or exerting unauthorized control over property with the intent to temporarily deprive the owner of the use thereof without the owner's consent, but not with the intent of permanently depriving the owner of the possession, use, or benefit of the owner's property. You understand that that's what the amendment is doing, is saying that you took it but without permission, but not to permanently deprive, but to temporarily deprive the owner?
Yes, ma'am.
And is that what you're wanting to admit or plead guilty to?
Yes, ma'am. I would.
All right. And is anyone making you enter this plea today by any threats or promises other than the plea agreement?
No, ma'am.
And do you understand that if I accept your plea, you'll most likely be found guilty and will not be able to have a trial?
Yes, ma'am.
And you won't be able to appeal your conviction if I accept your plea. Do you understand that?
Yes, ma'am.
Okay, so this happened on January 20th of 24?
Yes, ma'am.
And where in Butler County would this have happened?
On his property, on I think Blue Stem Road.
Okay, was that property belonging to a Justin Todd Bishop?
Yes, ma'am.
And what did you take from him that you
It was a burn barrel.
A burn barrel?
Yes, ma'am.
And did you know it was his burn barrel?
Yes, ma'am, I did.
Did you have permission to take it from Mr. Bishop?
No, I did not.
And you knew that?
Yes.
Why did you take his burn barrel?
I did some work for him earlier that week and he had not paid me yet. He kept on pushing it off and I shouldn't have jumped the gun, but I did.
So you took his burn barrel without permission?
Yes, ma'am, I did. I was gonna give it back, but whenever he paid me, but so I don't really have a use for a burn barrel, you know.
All right. So you took it, but you intended to give it back. Okay, well, I think that that meets the elements. And I do find you guilty of 21-5803, criminal deprivation of property. I will follow your plea agreement for sentencing and order a $200 fine and 12 months controlling sentence. You will get credit for any time you've been in the county jail for this case. Your court costs will be assessed at $158. What kind of job do you have, if any, when you're not there in jail?
Oh, I did have an interview at Taco Bell in Wichita, but I was actually thinking to get my roots back here because I don't want to. It's just too far out, and I need to be here for probation and also family reasons. But like, I don't need to be in Wichita, and my mom said she'd help me with working for her again.
What kind of work does she have for you?
Around the house, like working on the house itself and like the yard and like doing the fence, and like she pays me like she'll get the court costs paid. She's very good about paying me what I think I deserve.
Okay.
What kind of work do you do when you're not in
your
jail?
Attorney fees at this time, because it doesn't sound like you're presently gainfully employed. And you'll still be responsible for $200 fine and 158 court costs for a total due of $358. No, add $60 to that for probation supervision. No restitution. And your probation will be reporting to court services for 12 months. All standard conditions will apply. And you will need to make monthly payments on the money owed at the rate of 1/12 per month, starting with August 1st, 2024, and then you'll have an equal payment of 1/12 on the first of each month thereafter. You are to have no contact with the co-defendant. Who is the co-defendant?
That's Nicholas Weiner.
Okay, no contact with Nicholas, no contact with the victim, Justin Todd Bishop, or his property or his family. You are to contact court services immediately upon release. Their number the jail can give to you, but you contact them immediately. That's the first condition.
Yes, ma'am.
Is this the only case you're in jail on?
Yes.
Anything further, Mr. Regier?
One moment, Your Honor. Nothing further from the state, Your Honor.
From the defense, Mr. Andrews?
No, Your Honor.
All right, then, Ms. Stanley, do you have any questions before I let you go?
No, ma'am.
Okay, then you are excused from these proceedings.
Thank you.
You're welcome. Mr. Andrews, who else do you have?
Your Honor, my next case is Sarah Grapper, and I was going to see if I could get a breakout room with Ms. Grapper.
Ms. Grapper? Sarah Grapper?
And she is present. I can see her on the.
I see her as well. All right. Jen, could you put Ms. Grapper and Mr. Andrews in a breakout room? Okay, any other defense counsel that I've not addressed?
Crapper?
Gerard Scott, who do you have on here?
Your Honor, I'm here on a motion for forfeiture on bond. It is Amanda Harmon. Could the court inquire as to whether she's present?
Amanda Harmon, are you here?
Oh, grapper. I
And
thought
I
he
don't know
said
if the bonds
crapper.
person's here or not.
I'm on here. And I'm sorry, I'm actually walking right now. But this is Tyson, Miss Your Honor. Amanda, I actually booked her on Friday into Butler County.
Hang on, let me call the case. And
Okay.
if you could quit walking, that kind of.
Yeah, I am. I'm getting to the vehicle right now. Sorry, I'm out.
Keeps me from getting a little dizzy there. Okay.
Yeah.
On the record in 2022 TR 3025, State of Kansas versus Amanda Rose Harmon. Please announce appearances.
Jared Regier on behalf of the state, Your Honor.
Gerard Scott for Amanda Harmon.
Tyson Case, representing second chance bail bonds.
All right. And we are here for a motion for judgment on bond after the defendant failed to appear back in February. So,
Correct.
Mr. Scott, as her attorney, do you know where she is?
Your Honor, I did receive a message from her. I don't know if it was Thursday or Friday last week about, and I didn't quite understand the message, but it sounds like now hearing from the bondsman, it was accurate. But something about she was going to be in my office on Friday, and she taking care of everything. But I'm out of town, and so and I messaged her last night to tell her, hey, I'm not at my office for you to show. But I think this is just on the motion. I think maybe we need to set another court date. And I don't know if one was set when she rebonded. I don't
know that she has rebonded.
Yes, she
I'm
has.
trying to think of your last name.
Case.
Okay, Case. Nice and Case.
Yes.
Okay, would you please update the court on what you know about this missing defendant?
Okay, so Miss Harmon, she was under the impression once we were able to get in contact with her, she did have a little bit of a phone issue, but she was at the address that she had given us, just the same as she had always. She thought that she needed to just come to court today. I didn't know how I wanted that to go down, especially going into the weekend. So I just had her come and turn herself into me. I brought her personally into Butler County and booked her in on this case. And on Saturday morning, after her people came and paid and everything, I came back down and rebonded her out on the new bond. So she could get back out and then be, cleared on this. And I wanted to make sure I was here to make sure we were cleared on it.
All right. So you brought her in, turned her in, then she posted the new 5,000 cash or surety.
Correct.
And now she fails to appear again?
Well, let me see here. I think her new court date, this is where the confusion was. I think that her being booked into jail and them giving her the September court date, I think that that's the court date that she thought she needed to go to. And I honestly, I should have reiterated that, but I was kind of unsure too, because of the practices here in Sedgwick County are whenever we book somebody, we get a new court date and then I still show up, but they don't have to until the new court date. I apologize for that, for my misunderstanding.
Okay, so I don't have a copy of the bond yet that I'm aware of. Let me double check. Mr. Regier, do you?
One moment.
She bonded Saturday?
One moment, Your Honor.
Mr. Case, do you know what the new court date was? Because I don't have that.
Yes, I'm pulling it up right now. It's going to be September 4th at 9 a.m. Butler County Zoom.
Your Honor, after further review of the file, it would appear there is a 5,000 professional surety bond with a second chance bail bond with an appearance date of September 4th, 2024 at 9 a.m. This has just recently been brought to my attention. So under those circumstances, the state would move to withdraw the motion for judgment on bond at this time.
Well, now things start getting complicated. Because if you do that, she's already posted a new $5,000 bond. If you don't do that, then there's the issue of what happened to the $2,500 bond. I'm gonna leave her bond at 5,000, but it sounds like they're not gonna go after 2,500, Mr. Case.
Okay, so that means we're off of the 2,500. Is that what you're saying?
Mr. Regier, is that what your motion is suggesting? They're not gonna be brought back, so that the motion today, instead of going after the 2,500,
Your Honor, the motion for judgment on bond in this case that was filed on April 19th of 2024 with a notice of hearing for today's date, July 1st, 2024, does appear to refer to a 2,500 professional surety bond. The state has presented an oral motion to the court for a withdrawal of that same motion.
all right, so they're not seeking the 2,500.
I appreciate that.
But you're still on the hook if she disappears again for 5,000.
Correct. And we understand that that risk, and we're willing to take it, and I appreciate it. And as we're navigating, I'm trying to learn your guys' system, and I'm glad that I'm on here kind of getting it all figured out so I can bring it without any complications on your end. I have a other question before I get off of here for you real quick. I do have two others that one wasn't for a hearing today, but I do know that he was very wanted, and we have him in custody in Sedgwick County. He's Dylan Fieldmeyer. I do have a motion on him. I didn't know if I just needed to wait until that court date to try to come off of all those bonds. I have had holds, no bond holds put on all of his. It's about $40,000 out of Butler County. I do have all those in Sedgwick County. Do I need to wait to address this, or is that something we can address briefly?
Well, I'm not going to take it up today, obviously.
Yes.
If there are motions pending, there are forms, of course, that you can turn in showing that he's been surrendered somewhere with no bond holds. But as far as the motion for judgment on bond, if you want to contact the county attorney and see if they want to set aside their motion, that's between you and them. Otherwise, I'm going to leave it on the docket. But Mr. Andrews, I think that's one of your clients, isn't it?
Your Honor, he was a client of mine, and then he retained counsel, John Rapp. And so my appointment ended at that time. Now, I understand that Mr. Rapp has withdrawn as his attorney, so I would say he does not currently have counsel.
All right. Jen, I think he's got a number of cases. Dylan Filemeyer. And let's reappoint Mr. Andrews to all of his cases again, if you would, please. And if Mr. Andrews will take him again.
Yes, ma'am.
But as I'm recalling, Mr. Andrews, doesn't he have a list of cases?
He does, but I don't know what happened with them. When I spoke with Mr. Rapp, it was my understanding that a global plea agreement had been reached. And I'm not sure if that plea had ever been entered that disposed of the cases, or if the failure to appear occurred prior to the entry of the plea. So right. I don't know what the status is at this point.
Okay. Well, we'll let you and counsel figure that out. Sometimes those plea agreements, as you know, disappear if the defendant disappears. So,
Your Honor.
Mr. Regier.
Your Honor, for purposes of today's hearing, is the court finding that Mr. Andrews is first off, is the court going on the record in the Fieldmeyer cases? And secondly, is the court reappointing Mr. Andrews to all those cases? The state's understanding is that there are not any cases with the defendant by that last name on the docket today. So it seems that this is somewhat unusual as far as taking the matter up when it was not on the docket in the first place.
I'm not taking it up at all, other than to tell Jen I want Mr. Andrews reappointed just to save time, that when I do get him, he's got counsel.
Very good, Your Honor.
All right, thank you.
Your Honor, may I be accused?
Yes, Mr. Scott, I'm sorry. Yes.
But no problem. Hey, thanks.
You're welcome.
And Your Honor, is in the Amanda Harmon case on the docket today, is the court finding the matter continued to September 4th, 2024 at 9. That would appear to be the date on the 5,000 professional surety bond.
Well, technically, the only issue is motion for judgment on bond on this docket, and that has been withdrawn. And so I think that by default leaves her on that date, but you can put it however you want to. But yeah, she's continued to that date, or she's still on that date.
Very good, Your Honor.
Yeah. Mr. Case, you said you had some other issue?
Yes, ma'am. We have an Ashley Jones that I'm actually just appearing for Philip Webb. He's got a family emergency going on, so I was just gonna request an extension on Ashley Jones if that's what we're doing right now.
Well, I'm not seeing Ashley Jones. I'm seeing Antonio Jones, Mikhail Jones. Does anyone have an Ashley Jones on here? It's not one of those two, is it, Mr. Case? Antonio or Mikhail? Or
No.
Michael, might be Michael, M-I-K-A-L.
Nope, it says Ashley Jones. It must have been resolved if it's something. I'm just seeing it on my calendar, so.
Okay, Jen, you don't have it on the official calendar for today, do you?
No, I show it was canceled.
All right, canceled. Okay, Mr. Regier, you didn't have it?
One moment, Your Honor.
And so I'll just I'll have a bunch of release of sureties sent over for Phil Meyer today. That way we can work on that. And I'm not trying to address it right now, but I was just making it to you.
Your Honor, forgive me, there do appear to be two cases with the last name Jones in this case. Is this regards to Mikhail or Antonio?
Okay, it's not regards to either of those. The clerk shows whatever his concern was has been canceled, so I'm going to release you, Mr. Case, at this time.
Okay, thank you, ma'am.
So, Mr. Andrews, you ready for Sarah Grappler?
I am, Your Honor.
We're on the record in 2022 CR 415, State of Kansas versus Sarah Barbara Grappler. Grapper, please announce appearances.
Jared Regier on behalf of the state.
Joshua Andrews on behalf of Ms. Grapper, who is also present.
It looks like we are here because the defendant failed to appear April 22nd, 2024 on a misdemeanor control.
And I believe that Ms. Grapper...
The bondsman had asked for an extension to locate her, which was denied, and granted motion with a stay of execution for 30 days. May 3rd, the defendant still failed to appear.
I'm showing, Your Honor, that Ms. Grapper was arrested on April 26, 2024, and then bonded out on May 3rd.
She did appear at the Sally Port, did she?
Yeah, it looks like there was a first appearance on May 3rd, and she bonded out on that date. If I'm reading this, well, I don't want to guess on the signature, but and then
she has a long history of failing to appear, and we want it since January of 23, and we'd like to get this resolved. What's her situation today, Mr. Andrews?
It's my understanding we have entered into a agreement with the state in exchange for a plea to the possession of paraphernalia charge. The state is prepared to dismiss the possession of marijuana charge.
And that's your agreement, Mr. Regier?
One moment, Your Honor. Your Honor, after further review of the file, the state is prepared to proceed in that fashion.
All right, let's take that up. Ms. Grapper, how do you plead to count 2, possessing paraphernalia on June 21st, 2022 in Butler County?
Guilty.
Is anyone making you enter this plea of guilty by threats or promises other than the plea agreement?
No.
Do you understand that if you plead guilty, you're giving up your right to trial You'll most likely be found guilty and you'll not be able to appeal your conviction.
Yes.
Okay, now this charge says that on that date, you were in Butler County with drug paraphernalia. Where were you in Butler County?
I was in a vehicle in Leon, I believe.
All right, Leon, Kansas, that is in Butler County. And you said you were in a vehicle. Did you have in your possession in that vehicle a glass pipe?
Yes, ma'am.
And what was that pipe used by you for, or intended to be used for?
To smoke marijuana.
All right. And had you used it for smoking yet?
Yes.
Okay. All right, I will find you guilty of count 2, possession of drug paraphernalia. And on motion of the state per plea agreement, count 1 will be dismissed. Recommendations for sentencing, Mr. Regier?
Yes, Your Honor. Without having been a personal party to any purported plea agreements or rather negotiations between counsel for the defense in my office, at this time, the state is prepared to recommend no fine for count 2, $158 court costs. I will, of course, defer to the court on the issue of attorney fees, assuming that Mr. Andrews is appointed to this matter. State would further recommend $400 in KBI lab fee, a 6-month underlying sentence with 12 months of reporting probation, $6 probation fee with all standard conditions. I will, of course, defer to the court on the issue of repayment of the case.
Very well. Mr. Andrews, are those your understandings of the agreement?
Your Honor, there actually was not a joint sentencing recommendation component to the plea agreement. However, with that being said, I would join in the recommendations of the state as being appropriate in this case.
And are you appointed or retained?
I am appointed, Your Honor.
Okay, thank you. Ms. Grapper, tell me about yourself. Do you live in Leon?
No.
Where do you live? What town?
I live in Wichita.
Married or single?
I have a boyfriend.
Okay. Do you have children?
Yes, but they don't live with me.
Okay. And do you have a job?
I'm working on it right now. I'm kind of just doing here and there work, but I've been steady looking for a job. And I have an interview later this week, so hopefully that'll go good.
All right. I'll waive your attorney fees, but you do have to pay $158 in court costs, $400 to the KBI, and $60 for probation supervision. Your underlying term is 6 months. If you don't want to serve that 6 months in jail, you better make sure you're successful on probation. For 12 months, you must report to probation. You must violate no laws. You must use no illegal drugs. And that means no marijuana, because that's illegal federally and under Kansas laws. So don't be going to Missouri and using, because that's illegal under your probation.
Okay.
You'll be subject to random UAs and a hair follicle test. If probation sees concerns that you need an alcohol and drug evaluation, they have the authority of the court to require you to get that and to comply with it.
Okay.
You will pay 1/12 of the money due each month, with the first payment due August 1st, 2024. You will then be obligated to pay 1/12 on the first day of each month thereafter.
Okay.
You can always pay it earlier. The first condition of your probation is to contact probation as soon as this hearing is over. You must call them at 316-322-4153. Anything further, Mr. Regier?
Your Honor, is the court making any orders concerning a fine one way or another in this matter?
I am assessing no fine. Thank you for having me clarify that, counsel.
Very good, Your Honor.
Mr. Andrews, anything further?
Your Honor, does Court Services have permission to transfer supervision to Sedgwick County?
Yeah, yes, they do. They do. If that's, as long as that's their home county and they feel that that's appropriate, they can do that.
And that, I have nothing further here.
Mr. Andrews, before they do though, I've been in order that they get a UA on her and a hair follicle as soon as possible with the nanogram counts to make sure that any numbers in the future go down and not up. Frankly, Miss Grapper, you don't look quite as clean as I think maybe you should be if you're not using anymore.
As clean?
As clean. Looks like
Drug free. Not that was. I don't think the court was impugning your hygiene. It was
no, your hygiene looks fine. I just meant you look like you might be under the influence possibly of something. And maybe you're not. Maybe you're just tired. You don't have to address it. Just take the test and then we'll be fine. No, your hygiene.
All right.
All right. You may go if there's nothing further, Ms. Grapper, but call your probation officer.
All right. Thank you.
You're welcome.
Your Honor, I had one other case on the docket, if we could take that up.
Certainly. Who do you have?
Tanner Parscall. I was just appointed on Mr. Parscall. And I do see that he is present.
We're on the record in 2024 CR 100, State of Kansas versus Tanner Christopher Parscall. Please announce appearances.
Here on behalf of the state.
Joshua Andrews on behalf of Tanner Parscall, who does appear in person.
And how does he wish to proceed today?
Your Honor, as I said, I was just appointed on this case on, I think it was Thursday of last week. I haven't had a chance to look at anything on this matter. I would ask if we could continue this. And I would ask, if possible, if we could go out 45 to 60 days with Mr. Parscall present. I can schedule a time to meet with him after we're done with the hearing, and that would give me plenty of time to review the discovery, meet with Mr. Parscall, and form a plan as far as how we want to proceed with the case.
Any objection to that, Mr. Regier?
No objection to setting this matter over out of professional courtesy to Mr. Andrews. This is a case that does appear to have a $750 professional surety bond with all standard conditions previously executed. I am not sure if the court wants to make any orders concerning alcohol during the pendency of this case. Pursuant to the information filed in March of 2024, it does allege one count of purchase or consumption of alcoholic beverage by a minor, a Class C non-person misdemeanor.
Mr. Parscall, how are you? How old are you now?
I'm 18 years old, Your Honor.
All right. Well, your bond says don't violate any laws, and consuming or possessing alcohol is a violation of the law at your age. So make sure you don't get in trouble with that bond. I'm going to grant your attorney's request for continuance. I'm going to order that you have contact with your attorney for his directions between now and the next court date. Jen, are we still available for 9/9?
Yes, we are.
All right, this is going to be set over to September 9th at 9 a.m. And you are continued on that bond with the conditions that you violate no laws, that you comply with all other conditions on the bond, and I would emphasize no alcohol, no illegal drugs.
Yes, ma'am.
Anything further, Mr. Andrews?
Your Honor, if I could just have a breakout room with Mr. Parscall when we were finished, but other than that, nothing.
All right, Mr. Regier, anything further?
And that was the September 9th date, Your Honor?
Yes, 9/9 at 9.
Very good, Your Honor.
Thank you. All right, Mr. Parscall, you're excused from this hearing, but you have to stick around for a breakout room with your attorney. If Jen could put the two of you in a breakout room, please. Do I have any other defense attorneys in addition to Mr. Patterson on here?
And Judge.
Seeing none, Mr. Patterson, are you ready to take up the gentleman in the jail?
Yes, Your Honor, that would be Mr. Minifield.
Thank you. will be on the record in 2024 TR 1533, State of Kansas versus Amarius Jacques Amon Minifield. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Mr. Minifield, who does appear from Butler County Jail. Your Honor, would announce this time, Mr. Minifield will enter a plea of guilty to count 1, driving while suspended, and count 3, driving without a tag assigned. States agreed to dismiss count 2.
All right, and that is your agreement, Mr. Canfield?
It is, Your Honor.
And that's your agreement, Mr. Minifield?
Yes, Your Honor.
So how do you plead to count 1, driving while suspended in Butler County, Kansas on June 6th of 2024?
Guilty, Your Honor.
And how do you plead to count 3, operating a motor vehicle without a valid tag in Butler County, Kansas on June 6th of 2024?
Guilty, Your Honor.
Is anyone making you enter these pleas today by threats or promises other than this plea agreement?
No, Your Honor.
And do you understand if I accept these pleas, you'll be found guilty, you'll not have a trial, and you won't be able to appeal your conviction?
Yes, Your Honor.
All right. What makes you guilty of count 1, driving while suspended? In your own words.
I was pulled over without a license and tags that didn't belong to my car.
And what was wrong with your license at the time?
It was suspended for unpaid tickets.
Okay. And where'd you get pulled over, if you recall?
Butler County, El Dorado.
You were inside of the city limits, you think, of El Dorado?
Yes, yes, ma'am.
Okay. I will find you guilty. Recommendations for sentencing, Mr. Canfield?
Your Honor, in count 1, the state would recommend a fine of $100 with a 4-month underlying. In count 3, a $50 fine, 30-day underlying to be concurrent, both suspended for a 6-month non-reporting probation, as well as any costs or fees.
How long on the non-reporting?
6-month, Your Honor.
Mr. Patterson, anything further on probation recommendations or sentencing recommendations?
Your Honor, the only additional item we would have, he has been in jail since June 6th by my count. That would be 25 days. We'd ask for 25 days credit. He informs me he doesn't have any other holds, so he would expect that if the court follows this, he would be released.
Okay, thank you. Mr. Minifield, where are you from?
From Junction City, Kansas.
And did you have a job up there in Junction City?
Yes, Your Honor.
What kind of work did you do?
I would remodel Dollar Generals.
Okay, I think I remember that. Do you think you'll be able to get that job back?
Yes, Your Honor.
Very good. All right, well, I'm going to follow the recommendations. Your fine on count 1 will be the minimum required by law of $100, a 4-month or 120-day jail sentence. On the tag charge, $50 and a concurrent 30-day jail sentence. You will certainly get credit for the time served, the 25 days if Mr. Patterson's corrections or calculations are correct. You will have $108 in court costs. You will have $250 of attorney fees. You'll be put on a 6-month non-reporting probation. That probation will have about 2 conditions. Number 1, don't violate any laws during this 6 months if you don't want to go back and finish that 4-month sentence. And number 2, you have to pay the total due, which I believe is about $508. How much time do you think you'll need to pay $508?
Should be able to do it within the next 60 days, Your Honor.
All right, I'll give you 60 days to pay that. And make sure that you talk to the clerk before you leave so you know how to make the payments and where to make the payments. Because if you don't make those payments, you're going to get another suspension on your license, maybe even a habitual violator. You'll have a collection agent after you, garnishing your wages and bank accounts and so forth. And you'll have the possibility of your probation revoked and serve the balance of that sentence. But as long as you pay when you're supposed to and don't violate the law, you should never have to serve the rest of that. Okay?
Yes,
All
Your
right.
Honor.
Don't forget to check with the clerk for all the payment options where you can pay, because you can pay online. All right, anything further, counsel?
No, Your Honor.
Then we'll be in recess, and you may go, Mr. Minifield.
Am I being released today?
You're being released on this case. I don't know if you have anything else, but you're released on this. But don't forget to pay and don't violate the law.
Yes, ma'am.
Okay, anyone else in jail?
That's it, Your Honor.
All right, thank you so much.
Thank you.
Now then, I believe it looks like Deputy has someone ready for us to go. Is that one of Mr. Patterson's clients?
Yes, it is. It's Michael Jones.
Michael Jones. Mr. Patterson, are you ready on Michael Jones?
Yes, Your Honor.
And you're ready, Mr. Canfield?
Yes, Your Honor.
We are on the record in 2024 TR 110, State of Kansas versus Michael R. Jones. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Michael Jones. Mr. Jones does appear from Courthouse Security 1 video station. Your Honor, in this case, I would announce that this is the first opportunity I've had to speak with Mr. Jones. Upon talking with him, it becomes clear that he does need to get me some further information to help in his case. Asking the court to allow it to be set over one additional time.
Any objection, Mr. Canfield?
Your Honor, this is a first control hearing. No objection from the state.
Mr. Patterson, Mr. Jones, I'm going to set this over to 9/9 at 9. That's September 9th at 9 a.m. Mr. Jones, you better make sure you have anything your attorney needs before that date. Make sure you've talked to him and are ready to go. September 9th at 9 a.m. Anything further? You are continued on your bond, of course, Mr. Jones.
Nothing from the state, Your Honor.
Nothing further.
Recess. You may go, sir. And who do you have next, Deputy?
Yeah, Javel Eagle. Last name Eagle.
We are on the record in 2024 CR 182, State of Kansas versus Javel Leanne Eagle. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Javel Eagle. Miss Eagle does appear from Courthouse Security 1. Your Honor, would announce this time state has agreed to amend the charge to alleged disorderly conduct without a domestic violence tag. To that charge, Your Honor, Miss Eagle would enter a plea of no contest.
And that's your agreement, Mr. Canfield?
It is, Your Honor. I would just note that my office has attempted to contact the alleged victim in this case. We have sent letters via postal service as well as email and phone calls. We have not been able to have any contact with the victim, so the state is prepared to go forward with this plea today.
The alleged victim is Nicole Suzanne Eagle.
Yes, Your Honor.
Miss Eagle, how do you wish to plead to the amended charge of disorderly conduct? That is engaging in rude insult. Well, let me look that up.
And Judge, this is under the brawling portion of that.
Okay, and what's that statute number?
That is 216203.
So, Miss Eagle, the state is amending to allege that you did commit disorderly conduct on April 24th of 2024 in Butler County, Kansas, specifically by entering into an act which you knew or should have known would alarm, anger, or disturb others, or provoke an assault or other breach of the peace by, you said, brawling or fighting under section 1?
Yes, sir.
All right, by brawling or fighting. How do you wish to plead, Miss Eagle? Your attorney said no contest. Is that how you wish to plead? I'm sorry, how do you wish to plead? You're gonna have to get in front of the microphone and speak up.
Yes.
She's talking to the side of the mic instead of right at it.
Where is it? Sorry. Yes, yes, Judge.
All right, you said yes, you want to plead?
Yes. Sorry. Yes, ma'am.
There you go. Now I'm hearing you. You're pleading how?
No contest.
All right, so you're not going to admit the charge, but you're not going to deny it and take it to trial either?
Yes, ma'am.
And do you know that by a no contest plea, you'll still most likely be found guilty and unable to appeal your sentence or your conviction? I'm sorry, you could appeal the sentence, but you won't be able to appeal your conviction? Can you say that where the microphone can pick you up?
Yes, ma'am.
And do you understand that with this plea, you're giving up your right to trial?
Yes, ma'am.
And is that what you want to do?
Yes, ma'am.
All right. Is anyone making you enter this plea today?
No, ma'am.
All right, Mr. Canfield, have you a factual basis to support a no contest plea to disorderly conduct?
Your Honor, should this case proceed to trial, the state would show through testimony or other evidence that on or about April 24th of 2024, law enforcement was dispatched to 113 East Locust Avenue, Lot 3, here in El Dorado, Butler County, Kansas, for reports of physical disturbance. Once law enforcement arrived, they learned that the defendant, Javelle Eagle, had been into a fight with Nicole Eagle. The defendant knew that this fight would alarm, anger, or disturb Nicole Eagle. And for the court's information, Nicole Eagle is the defendant's mother. However, the state is not requesting a domestic violence tag for this plea.
All right, the court will find the defendant knowingly and voluntarily entered a no contest plea, that a factual basis exists to support disorderly conduct. Therefore, the defendant is found guilty of disorderly conduct under KSA 21-6203A1. A domestic tag is not included on this amended charge. Recommendations for sentencing, Mr. Canfield?
Your Honor, the state is not requesting a fine in this case, but is requesting a 30-day underlying with a 6-month court services probation. I would also ask that the defendant follow any recommendations of medication management by South Central Mental Health, as well as any South Central recommendations regarding therapy appointments, case management, as well as continued no contact with the alleged victim, Nicole Eagle.
Mr. Patterson, anything further?
Your Honor, we are asking the court to adopt those recommendations. We have provided to the state a letter from South Central Mental Health that does indicate she is currently actively involved in medication management. She is currently actively involved in individual therapy, as well as case management. And generally, she has her case manager with her, which may be today also. But Judge, we just ask that the court adopt the recommendations.
Thank you, Mr. Patterson. Is your case manager there with you, Ms. Eagle?
Yes, ma'am.
Okay. And do you have a job, Ms. Eagle?
I am disabled.
Disabled? Okay. At this time, I'm not going to assess a fine. You will be responsible $158 court costs, as well as $60 probation supervision. I will waive your attorney fees. Looks like you're going to owe about $218 total. Your sentence will be for 30 days, but if you don't want to spend 30 days in the county jail, Miss Eagle, it's very important that you hear the rest of what I'm going to say. I will put you on a 6-month probation, but as long as you complete it successfully, you will not have to go to jail for 30 days. Now, what you have to do on that probation to keep out of jail is to contact probation before you leave the courthouse today, and the officers can direct you there. And then you have to go through a list of standard conditions with your probation officer. Very important is that you comply with your med management and your individual treatment and your case management services. At least at this time, you're to have no contact with Miss Nicole Suzanne Eagle, and you're not to have any contact unless something is brought before me to make me change my mind. So if you do that for 6 months, you don't violate the law, you comply with South Central, don't have any contact with your mom, and then find a way to get this money paid, then you won't have to serve your jail time. But with this $218, I want you to pay Can you afford to pay $40 a month, do you think, towards that? Okay. So I'm going to order that you pay $40 a month. And can you make your first payment on August 1st? Or do we need to make it a little? Okay. I keep seeing yes, ma'am. I'm not hearing it, but I'm seeing it. All right, I'll make your first payment due August 1st, and then each month thereafter until paid in full on the 1st of the month. If your probation officer sits down with you and finds out that that's not
you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so the court, please. Everything.
that the evidence Tony, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please. Your name. Thank you. Be seated. Court is still in session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m., Your Honor? And I would appear for my client.
Is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates, so.
What about, okay. What about the 19th and 9th? Is that whole week?
No, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so the court knows Ms. Little and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not.
Okay. So you and your client will be here in person, Ms. Giannetti?
Yes.
All right. All right. Thank you. We'll see you then.
All rise.
We have a ceiling fan again. Wow. Oh, nope, we're done. Okay. So real quick, there was a couple questions. Sorry, I'm not used to this, having to press all these buttons. Principles and moral convictions. I thought for juries you could bring your preconceived notions or ideas into play. I think you mean couldn't, shouldn't, right? But if you think of it, some people look at the evidence differently. If you've looked on social media anytime soon, oh, let's turn some lights on in this mother. Let there be light. There's people on social media who firmly believe that she is guilty. Look, that FBI chick who always has stuff wrong, Coffindoffer. She is hardcore. This lady is guilty. Like, 100%, no matter what. Law enforcement, end of story. Like, I'm not looking past that. You're not changing her mind, no matter what you say or what you do. She is guilty in her mind. There are other people who say that it's not possible. There's physics and I don't know, whatever math comes into play to make that happen, that it's not possible. Timelines and this and that, everything that they've presented is not possible. There is reasonable doubt, which is all you have to have. You have to have some kind of doubt. And if you have any doubt at all, then that just takes it all away. You can't be guilty if there's any kind of doubt. Why's my hair all over to the side? Anyways, so yes, most people believed that those injuries could not have been caused with contact with a car. And my biggest thing is he had a skull fracture in the back of his head. What was that caused by? And hitting it on the ground? Well, yeah, but the ground was covered with snow, and it was fresh snow, from what I understood. And I don't know much about snow, and I'll be the first to admit I don't know much about north. I've only seen it once or twice, but I mean, if it's freshly snowing, it's not compacted or icy yet, right? So it probably isn't hard enough to crack your skull, is it? I don't know. That just, I need more. I need more than just that. And if you fell backwards, because the crack in your skull instantly rendered him unconscious, how do you get blood all over the front of his shirt? He's checking out the kitty cats on my shirt. Canfield likes my kitty cats. So I don't know. I think there's enough going on in there to make somebody say, huh? And I think the defense raised enough questions. They don't have to convince you that there's this big conspiracy cover-up, everybody's involved in it. All they have to do is make you say, well, something's not right here. And as long as there's a little bit of a doubt, that's all it takes. Some people don't recognize that little bit of doubt. They overlook that and think she has to be guilty because there's no way anything else happened. And they go straight with that. And that was probably the people who were immovable in their position. And I really think the state is going to think long and hard before they retry this case because they don't have a cut and dry case. I mean, they may be able to present it better. I don't know. I can't see them winning this unless there's some other evidence that we didn't see. Unless they really clean it up. But I think there's too much weird stuff happened that can't be explained. And anytime you use red Solo cups at a crime scene, you're gonna have questions. In my opinion. So. I am going to let you all finish watching Butler County. And then I gotta go get some work done today, because I've been sitting here doing nothing all day. But thanks for hanging out with me while we watch the ceiling fan. I'm gonna miss the ceiling fan. I might have to start a stream of just my ceiling fan. Maybe? I don't know. We'll see. All right. There's that.
Not going to work. They can make another proposal on the payment. The rest of that you have to do. Okay, anything further, counsel?
Just to be clear, Your Honor, that was with court services, correct?
Yes.
Thank you. Nothing further.
Nothing further.
Okay, there you go. Good luck to you, Miss Eagle. You're welcome. Officer?
Robert Cooey, Cooey starting with an E, or with a C, I'm sorry.
Robert Cooey. We are on the record in 2023 TR 1167, State of Kansas versus Robert Andrew Cooey. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Robert Cooey. Mr. Cooey does appear from Courthouse Security Station 1. Your Honor, I would announce at this time, Mr. Cooey will be entering a plea of guilty to speeding and count 1 speeding, also count 3 driving while habitual. States agreed to dismiss count 2.
And 4 and 5? Oh, no, 5 is habitual.
I'm sorry, count 5. The others I think were previously dismissed. I think there's an amended information.
Oh, okay, well, let me check.
Yes,
that.
Your Honor. An amended information was filed on May 16th of 2023, which dismissed counts 3 and 4.
Right, so we have a plea to speeding 92 and a 55 in count 1. And a plea to count count 5 habitual violator. As you said, counts 3 and 4 dismissed. Count 2 to be dismissed today. Is that all correct?
Yes, Your Honor.
Okay. So, Mr. Cooey, how do you plead to count 1, speeding 92 miles per hour in a 55 mile per hour zone on March 25th, 2023 in Butler County, Kansas? Okay, there's something about that microphone system that I just can't pick them up.
Speak directly into it and speak loud. You're very
guilty, ma'am.
Very good. And how do you plead? And I say very good as to the volume and the clarity, not very good that you're pleading, but how do you plead to count 5 driving in Butler County, Kansas on March 25th, 2023 after you'd been declared or while you'd been declared an habitual violator?
Guilty, ma'am.
Is anyone making you enter these pleas of guilty today by threats or promises other than your plea agreement? Can you put him? I think he needs to scoot over a little. There you go. Now, your response, how do you plead?
No, ma'am.
Guilty?
Guilty.
And are you pleading guilty because you feel you are guilty of these 2 charges?
Yes, ma'am.
Is anyone making you enter this plea by threats or promises other than that plea agreement? And you're getting a little to the side there. Stay over and louder. And do you understand you're giving up your right to a trial? Do you understand you're giving up your right to a trial, sir?
Yes, ma'am.
And you understand that you'll be found guilty and unable to appeal your conviction.
Yes, ma'am.
Now, where were you driving on March 25th to 23 that would have put you in Butler County?
Driving.
Scoot over that way a little bit and talk louder.
I believe I was in Butler County. I can't remember the exact road.
Okay, I want to make sure that the court reporter can pick that up. Are the rest of you hearing that okay?
It is very quiet, Your Honor, but I can make out what the defendant is saying.
All right, well, sir, if you would just lean forward and speak louder, I want to make sure that if we ever need the transcription, that they can hear it, and I want to make sure I can hear
I believe I was in Butler County. I'm actually pretty sure I was in Butler County, but I can't
All right.
remember the
it. Where
exact.
were you when you got stopped?
Cannot remember the exact road.
What road were you on, if you know?
It was off toward Rose Hill area. I can't remember the exact road.
Okay, so where are you coming from?
I was coming from Butler County and I was going to Sumner County to see my kids.
And Judge,
Okay.
the NTA says Southwest 210th and a half mile west of Butler Road.
Does that sound right, sir? Is that where you probably were?
Yes, ma'am.
And the speed limit in that was a 2-lane county road, probably? You're drifting away from me again. I have to do something about that microphone system down there. I can hear the officer great, but then when the defendants come in, they're just real faint. All right. The posted speed limit was 65. Is that right, sir?
Yes, ma'am.
And how fast were you going? Were you going 92 like the officer said?
Yes, ma'am.
And at the time, was your license revoked because you were a habitual violator?
Yes, ma'am.
All right, I accept your plea and find you guilty. Recommendations for sentencing?
Your Honor, in count 1, the speeding, the state would recommend the scheduled fine, which is $300. And in count 5, a fine of $200, a 6-month underlying, suspended for a 12-month court services probation, as well as any costs or fees.
Mr. Patterson, anything further?
We'd ask court to adopt the recommendations, Your Honor.
All right, Mr. Cooey again, speaking louder into the microphone. Are you employed at this time?
Yes, ma'am.
Where do you work?
Plus.
One more time.
Herbs Plus.
Curbs Plus, all right. Full time?
Yes, ma'am.
At this time, I'm going to sentence you to 6 months in the Butler County Jail. Your fine will be on count 1, $300, and count 2, $200. Your court costs will be $108. Your supervision fees will be $60, and your attorney fees will be $250. I believe that comes to about 1,018, somewhere in that ballpark. And if you don't want to go back and serve 6 months in the county jail, you better make sure that you complete this 12-month supervised probation successfully, completely, and on time. All standard conditions will apply. You're ordered to go to probation when you leave this hearing. They'll set up a time and go over all those conditions. You're going to pay 1/12 of the total due each month. The first 12th will be due on August 1st. And then on the first day of each month thereafter, you'll pay 1/12. You will violate no laws if you don't want to go back to jail. And are there any other specifics that I'm overlooking, Mr. Canfield?
No, Your Honor, that was with court services, correct?
That is court services, yes. Mr. Patterson, anything further?
Nothing further, Judge.
All right, Mr. Cooey, go to court services, get started and do well, so you don't have to come back.
Ma'am.
Thank you, sir.
Next one I have is Richard Mangum. Or speak aloud into this microphone. We're having a little hard time with that.
Okay. All right, we're on the record in 2024 TR 107, State of Kansas versus Richard James Mangum. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Richard Mangum, who does appear from Courthouse Security 1 video station.
Okay.
Judge, I am asking for one additional continuance in this case. I'm having some difficulties with Kansas Department of Revenue on some issues that I'm trying to get sorted out to make sure I understand the rules very carefully so that I can advise my clients properly. There's seems to be some suspensions on certain things that I guess I didn't realize they were doing. So I need some additional time to make sure I can advise Mr. Mangum appropriately.
How about that September 9th at 9 a.m.?
Yes, Your Honor.
Unless Jen tells me we don't have any more time, then we'll put it there. Is that all right, Jen?
September 9th works. Don't forget, you also have plenty of room on August 26th.
Oh, well, let's take up August 26th too. But not you. You stick to 9/9. All right. So, Mr. Mangum, any bond you're on is continued with the added condition that you reappear 9/9 at 9 a.m.
Yes, Your Honor.
All right. If there's nothing further, Mr. Mangum is excused. You may go, sir.
Richard, I'll be in touch with you.
Thank you. Next, I have a Richard Baker.
We'll be on the record in 2023 TR 564, State of Kansas versus Richard Kyle Baker. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Richard Baker. Mr. Baker does appear from Courthouse Security 1. Your Honor, this is a case where Mr. Baker appears either on a bench warrant or on a warrant to show cause. I'm not certain which, but needless to say, the sole allegation is that previously the court had ordered he serve 5 days, 2 48-hour periods, followed by a 24-hour period. That the allegation is that he failed to appear to jail for the 24-hour period, and he does not dispute that and does stipulate. I would further, just for the court's information and recollection, this is a case where he did need to reschedule. He used email to reach out to the court clerk to reschedule. The last time that he did that, the court did authorize the rescheduling of the 24-hour period, but left it to the state. And the state did file the warrant, which he's been arrested on at this point. So through all of that, Judge, I would just tell the court, he does acknowledge he has not served that 24 hours, does stipulate to that as being any type of violation, and does waive hearing on that issue, Your Honor.
Mr. Baker, the court's heard that you want to stipulate that you violated your probation. Is that right?
Yes, ma'am.
And did you waive any evidentiary hearing in that regard?
Yes, Your Honor.
I don't need the jail, in other words, to come and testify that you didn't show up?
No, ma'am.
Okay. I find that you have violated your probation, knowingly and voluntarily waiving your right to hearing. Recommendations, Mr. Canfield?
And Your Honor, I do just want to add on a bit to what Mr. Patterson said. There was a warrant that I had issued. The defendant was picked up on that warrant. It was for missing the 24-hour sanction time. I had issued this as an arrest warrant. Mr. Regier believed it should have been a warrant to show cause. After the defendant was picked up on the arrest warrant, Mr. Regier did issue that warrant to show cause. So I would just ask that any warrants be withdrawn after today, as the recommendation, my understanding is a joint recommendation, that the defendant go immediately to the Butler County Jail to serve the 24-hour sanction.
Anything further, Mr. Patterson?
The only additional statement, Your Honor, would be that once Mr. Canfield had filed that warrant, my client became aware of it, turned himself in, and just wanted to get it resolved immediately. So he knows what is going on, that he did fail to appear. So we'd ask the court to adopt the recommendations that he be taken into custody and served 24 hours immediately.
Have you made anything on your case, sir?
I was actually getting ready to. I was in the clerk's office going to make a payment right there, and they had me wait. So I asked the deputy, and I figured it'd probably be best for me not to miss my name calling, because they were having me wait in there and no one was available for me to pay right then. But I had told Mr. Patterson I'm prepared to take care of about 90% of, I think it was like 208. I could pay 175, 150, 175 right now and get it taken care of. And then I could take care of the rest as soon as I'm out. I'll get paid again on Thursday. So, or it'll be Wednesday night.
So you were supposed to serve your sanction clear back in February. We modified it so you could serve it later in February. Actually, you were sentenced in January. You were to serve 5 days in jail, 48 hours on January 26th. Another 48 beginning February 9th, and 24. So how much of those 3 weekends did you report to?
I did 4 of the 5 days, Your Honor.
And Your Honor, Mr. Patterson, I did confirm that with the jail. The defendant has served 4 total days.
But not at the times told to serve them, just kind of hit and miss.
Yes, Your Honor, the first time the defendant had missed, I believe, was a 48-hour. It may have been the 24. The state agreed to amending the dates that the defendant would need to report. The defendant then requested a second time to reschedule, which is when I agreed or issued a warrant. I apologize.
So are you still working, Mr. Baker?
Yes, ma'am.
Where do you work?
I work for Aerospace Turbine out of Arkansas.
What's your work schedule?
Well, I work Monday through Friday from 7 till anywhere from like 4 to 5-ish.
And Judge, just for the court does know, he does live in Arkansas. He was driving in for those weekends. So that it's a matter that whatever time the court has him serve, he'll be doing it without working.
Did you get your personal issues fixed up? Are they better, Mr. Baker?
They're as good as they can be, Your Honor. Yes, ma'am. I wouldn't say they're fixed, but they're as good as they can be.
Well, Mr. Baker, when you're given a probation condition, you're to do it. And we have just made lots of concessions for you. You've just kind of been doing what you want when you want, and that's not the way probation works. You should have known that because you had a prior driving while suspended charge and conviction. Do you have your license reinstated yet?
No, ma'am. I'm suspended for another, I think, 6 months, I believe, and then I can after that.
So how'd
Well,
you
that's
drive
in the
into
state.
court? How'd you drive into court today if your license isn't fixed?
I was dropped off.
Who's gonna pick you back up?
My sister, she lives here in Augusta.
So did she drive clear to Arkansas and get you?
No, I flew in and then she picked me up.
When do you go back to work again?
I go back to work on Wednesday and then off Thursday for 4th of July and then Friday.
So you don't go back to work until Wednesday?
Yeah.
I'm gonna order that you be taken into custody immediately, that you be taken to the jail, and that you serve. Do you have plane tickets to go back?
Yes, ma'am.
When do you go back?
Wednesday morning. 7:20, I believe.
I'm gonna order that you get out of jail Okay. In order that you serve 72 hours in the county jail, and then that you be put on reporting probation, as you seem to need more supervision than what you're able to handle on your own right now. So as soon as you get out of jail, you need to report to probation. The officers can give you the information for that. If you can all standard conditions to apply. You're to get this paid off in full. You're to violate no laws. And that'll be the order of the court at this time.
Your Honor, will the court authorize phone or video reporting if the probation office will allow that?
Certainly.
Thank you.
All right.
In your honor,
Mr. Patterson or Mr. Canfield?
the defendant was originally sentenced back in January to a 12-month probation. Will this court services probation be 12 months from the sentencing date?
It'll be 12 months from today, but he can ask for early termination if probation thinks it appropriate.
Thank you, Your Honor. Nothing further.
All right. And I'm gonna take a step further. I'm going to order that he gets his license reinstated if at all possible. By that I mean unless he's a habitual violator and can't. But if he's going to be driving around the country working, he needs to have a valid license. So that's the order as well. Okay, you may go, Mr. Baker, but you're in custody. Deputy, make sure he's remanded to the sheriff.
Judge, I have three more, but I don't believe they're Mr. Patterson's. They're motion for judgment on bond, and one guy needs to hire an attorney.
Was one of them Christian Austin? No.
No.
Bush? Well, who do you have? Who just bring him in real fast.
I have Michael Markey.
Okay, let's bring him in.
Judge, while you are doing that, may I have a breakout room with James Abel?
Yes. Jen, can you help them with that? Okay, this is Michael Markey. I had him marked off for some reason. We're on the record in 2024 CR 184, State of Kansas versus Michael Clayton Markey. Jared Regier for the state. Mr. Markey appears in person and pro se. Mr. Markey, you were here one other time. That was April 26th of 24 for first appearance. You pled not guilty. You said you were going to hire your own attorney. So the court gave you till today to do that. Where's your attorney?
I have tried to get one, and all they wouldn't want to take the case. All they wanted to do was give me advice. And I spoke with Mr. Patterson's receptionist the other day, and she told me to come here and apply for a court-appointed attorney.
Okay. Have you done that? Did you fill out a form?
I did last time.
Well, that's not what I'm showing. I'm showing that you said you were going to hire your own. I'm not seeing one in the file. So where are you working, Mr. Markey?
USD 375.
You work at what?
Oh, I work at the high school, the Circle School District.
Okay. And what do you do at Circle?
I am a maintenance man.
And what do they pay you per month?
They pay me per month.
How much per month?
Like $15 an hour, but
you don't know what your monthly paycheck is?
no, not really. It all depends. I missed work for a while. I've been very sick. I was in the ICU for a couple weeks. I got sick. And
did you have health insurance through the school that paid for that?
no, I have a disability, and it's through the Social Security disability.
All right. So is your $15 an hour on top of your Social Security benefits?
No, I don't get Social Security benefits. I just get insurance through the state because of my disability that I have.
Are you married or single?
I am single.
Do you support any minor children or legally support any children?
No.
Okay. Do you pay any kind of rent or house payment?
Yes.
How much?
I pay $750 a month for rent.
$750?
Yes.
And what do you pay for utilities?
$100 probably for electric, and $100 for my phone. $80 for water bill.
Do you have any other income?
No.
All right, I will appoint Mr. Patterson to represent you. So go back and give them all your contact information. And I'm going to set your court date over for August 26th at 9 a.m. Make sure you talk to Mr. Patterson about your case before August 26th at 9 a.m.
Absolutely.
And it looks like you have posted a bond. I will continue the bond with the conditions that are on it right now. Make sure you don't go around anyone that is the subject of this protective order. Make sure that you follow all the laws and don't violate any. Make sure you talk to Mr. Patterson and be back here August 26th at 9 a.m.
Okay, thank you very much.
You're welcome. Mr. Regier, anything further on this matter?
Your Honor,
Yes.
this is a case where pursuant to the information filed, there is at least one count of violation of protective order. If the court is continuing the prior orders concerning no contact with the victim, as well as anyone subject to the protective order, the state has nothing further.
And the court does make those orders. So make
Very
sure
good,
you
Your Honor.
don't go around anyone in that protective order. All right, you're free to go for now,
Thank
sir.
you very much. Have a good
You're
day.
welcome. You too.
Next one I have is Tashina Reed. Reed, R-E-I-D. You need to speak aloud directly.
What's your name, please? Okay, you have to speak a whole lot louder.
Tajane Reed.
Will be on the record in 2023 TR 1443, State of Kansas versus Tajane M. Reed. Jared Regier for the state. Miss Reed in person and pro se. This is scheduled as motion for judgment on bond. You failed to appear as ordered, Miss Reed. Why was that?
I didn't know I had court that day. Actually, I did know, but I went to the wrong place. I went to Sedgwick County, and it was supposed to be here in El Dorado.
Okay. And you're here because what? You found out that there was this motion pending? How did you know you had court today?
The bondsman.
All right. Well, you've never been here on your charges from what I can tell. You're accused in count 1 of operating a motor vehicle without the proper license plate. This is an unclassified misdemeanor, which means that your sentence could be anywhere from 30 days to 6 months. Your fine could be up to $2,500. In count 2, you're accused of operating without liability insurance. If you had insurance, you can get proof of that to the prosecutor and he may dismiss it. If you truly had no insurance at the time of the stop, then you're looking at a B misdemeanor. The penalties include a minimum fine of $300 up to $1,000 and up to 6 months in the county jail. In count 3, you're accused of driving while you were suspended after a previous charge of driving while suspended. Because of the prior conviction, that would elevate this to a Class A non-person misdemeanor. And that means your jail sentence could be up to $2,500. That means, or your jail sentence could be up to 1 year and your fine could be up to $2,500. I see an amended information, but those are the charges that you're showing, Mr. Regier.
Your Honor, pursuant to the amended information filed with the court, in July of 2023. It does appear to allege 3 separate counts. Driving a vehicle without the tag assigned to such vehicle under KSA 8142, no proof of insurance as a Class B non-person misdemeanor, and driving while license suspended or canceled a Class A non-person misdemeanor.
All right, thank you. So are you going to hire an attorney, apply for court appointed, or waive counsel and represent yourself, noting that there may be some jail time that you have to actually serve on that, at least on that driving while suspended? Okay, I can't hear you. You're gonna have
I
to
need
get
an
in front of the
attorney.
microphone.
I need an attorney.
You need to hire an attorney or apply for court appointed.
Apply for one.
Okay, if you want to apply, you're gonna have to stay close to that microphone, because I'm gonna have to ask you some questions. Starting with, where do you work?
I don't have a job.
How long have you been unemployed?
Years. 2 years.
2 years? Why do
Yes,
you not
ma'am.
work?
I just don't have the resources for a job right now.
Well, I think a lot of times the job will give you resources. So I'm not sure what you mean you don't have the resources to work.
I don't have transportation or no way to get to a job.
Okay, do you have children?
No,
Do you have a spouse?
no.
Who supports you?
My parents.
Your friends? Do you have a permanent residence?
My parents.
Oh, your parents, okay. And you're how old?
I'm 19.
32?
I'm 19.
Oh, 19. Like I said, you have to stay close to that microphone. You're 19. Do you go to school?
Yes, I just graduated this year.
From high school?
Yes, ma'am.
Okay, well, that's a different story then. I will appoint Attorney Darren Patterson to represent you, and the officers can give you the information. I'm going to order that you walk across the street after court immediately to Darren Patterson's office and tell him how he can find you.
Yes, ma'am.
I'm going to reset your case for August 26th at 9 a.m. You can appear by Zoom. That's August 26th at 9 a.m. What town do you live in?
Wichita.
Wichita, okay. But make sure that you've got a good connection where I can hear you. And I'll continue your bond with the conditions that you reappear here August 26th at 9 a.m. with the condition that you go to Mr. Patterson's office right after court, and that you violate no laws and comply with any and all other conditions on your existing bond. Mr. Regier, anything further?
Yes, Your Honor, 2 points. Based off my notes, it would appear that in this file there was a previous bond in the file for an appearance date on February 21st, 2024 at 9 for 2,000 professional surety. It would appear that prior to today's hearing, there were 2 consecutive failures to appear both in September and February of 2023 and 2024 respectively. My notes do indicate that the court did enter certain orders following the second consecutive failure to appear, and I am not showing any new bonds in the file. So the state will be requesting clarification from the court as to that particular issue first.
You are going to have to make a new bond. What about the motion for judgment on bond, counsel? You filed a motion for judgment on the 2,000 as I see it.
Yes, Your Honor, and under these particular circumstances, the state is prepared to request that be withdrawn at this time.
All right, I will withdraw the motion for judgment on bond and reinstate your previous bond as long as your bondsman will tolerate that. Have you been in contact with your bondsman? Who is your bondsman? Is it Sarah Recheck?
Philip Talbert. Philip Talbert.
Is the bondsman here?
No. His wife is here.
Who's his wife? Is the bondsman's wife here? If you are, can you identify yourself?
Yes.
Yes, ma'am. My name is Latanya Talbot.
Okay, what's your name?
Latanya Talbot.
Okay, Latanya Talbot?
Yes.
And
Talbert.
Thank you. Are you willing to continue her bond if I reinstate it?
Yes, he's willing to continue it.
Then that will be the order of the court. Thank you.
And Your Honor,
And the motion for judgment is set aside. Yes, Mr. Regier?
is the court making any orders if if the court is if the court is reinstating the prior bond, is the court making any orders concerning its prior orders from the last hearing?
Specifically,
Your Honor, I believe the court.
withdrawing the warrants, yes.
Very good, Your Honor.
All right, I'm going to withdraw your warrant. I'm going to set aside the motion for judgment on bond, reinstating the previous bond, but make sure you come to court when you're supposed to. Make sure you see your defense attorney, and that'll be all for now. Thank you. And I appreciate the bondsman bringing you in, or the bondsman's wife. You may go.
Thank you. Have a nice day.